We have answered the question whether an application for anticipatory bail under Section 438 of the Code of Criminal Procedure, 1973, is maintainable at the instance of an accused while he is already in judicial custody in connection with his involvement in a different case. Our final conclusion is as under. An accused is entitled to seek anticipatory bail in connection with an offense, so long as he is not arrested in relation to that offense. Once he is arrested, the only remedy available to him is to apply for regular bail, either under Section 437 or Section 439 of the CRPC, as the case may be. This is evident from Para 39 of Gurbakh Singh Sibia. 2. There is no express or implied restriction in the CRPC in any other statute that prohibits the Court of Session or the High Court from entertaining and deciding an anticipatory bail application in relation to an offense while the applicant is in custody in relation to a different offense. No restriction can be read into Section 438 of the CRPC to preclude an accused from applying for anticipatory bail in relation to an offense while he is in custody in a different offense, as that would be against the purport of the provision and the intent of the legislature. The only restriction on the power of the court to grant anticipatory bail under Section 438 of the CRPC is the one prescribed under subsection 4 of Section 438 of the CRPC and in other statutes like the Atrocity Act, etc. 3. While a person already in custody in connection with a particular offense apprehends arrest in a different offense, then the subsequent offense is a separate offense for all practical purposes. This would necessarily imply that all rights conferred by the statute on the accused as well as the investigating agency in relation to the subsequent offense are independently protected. 4. The investigating agency, if it deems necessary for the purpose of interrogation/investigation in an offense, can seek remand of the accused while he is in custody in connection with a previous offense, so long as no order granting anticipatory bail has been passed in relation to the subsequent offense. However, if an order granting anticipatory bail in relation to the subsequent offense is obtained by the accused, it shall no longer be open to the investigating agency to seek remand of the accused in relation to the subsequent offense. Similarly, if an order of police remand is passed before the accused is able to obtain anticipatory bail, it would thereafter not be open to the accused to seek anticipatory bail, and the only option available to him would be to seek regular bail. 5. We are at one with Mr. Dave that the right of an accused to protect his personal liberty within the contours of Article 21 of the Constitution of India, with the aid of the provision of anticipatory bail as enshrined under Section 438 of the CRPC, cannot be defeated or thwarted without a valid procedure established by law. He is right in his submission that such procedure should also pass the test of fairness, reasonableness, and manifest non-arbitrariness on the anvil of Article 14 of the Constitution of India. 6. Under Section 438 of the CRPC, the precondition for a person to apply for pre-arrest bail is a reason to believe that he may be arrested on an accusation of having committed a non-bailable offense. Therefore, the only precondition for exercising the said right is the apprehension of the accused that he is likely to be arrested. In view of the discussion in the preceding paragraphs, custody in one case does not have the effect of taking away the apprehension of arrest in a different case. 7. If the interpretation as sought to be put forward by Mr. Luthra is to be accepted, the same would not only defeat the right of a person to apply for pre-arrest bail under Section 438 of the CRPC, but may also lead to absurd situations in its practical application. So we have also explained why Narinderjit Singh Sani should not come in the way of applying. So we are dismissing the appeal with a clarification that now the bail will be heard on its own merits. Beautifully read. Thank you. You are appearing? We have allowed the petition. We appoint Shri Justice Mohit S. Shah, former Chief Justice of the High Court of Judicature at Bombay, to act as the sole arbitrator. The fees of the arbitrator, including other modalities, shall be fixed in consultation with parties. It is made clear that all the rights and contentions of the parties are left open for adjudication by the learned arbitrator. Finally, fine.
In 1502, I'm not in the matter, I have nothing to do with the merits. But when your lordships were hearing the constitution bench on this issue, Lord, my lords were pleased to require the original file of the government to be placed for my lord's consideration, which was placed. Lord, if that can be returned.
Can be returned.
Yes.
When the 7-judge matter was going.
Yes, at that time, my lords.
Yes, of course, that. Make sure that is returned to the Solicitor General.
Lords, if I can mention, my lords, there's a matter for which we have sent an email. We have also gone between 10 and 10:30, as the lordships have mentioned. It's listed tomorrow before the single judge division bench of the Madras High Court. Despite judgments of the Madras High Court which say quashing petitions must be heard by single judges, about 30 matters have been heard and disposed of. We're a little concerned.
Yes, all other mentioning applications, the moment we rise, I'll pass orders so that we'll have orders by the
except for these are matters before your lordships after notice matters. Lords, concerning the university which your lordships have been hearing in part. Lords. Sorry, my lords. Because it was last listed before your lordship's bench, my lords, on 13th of February, my lords. Since then it has not come up. It's showing on 13th of October. It may not be deleted because there's some.
All non-deletion requests also just give us in an email and make sure that I pass
it. Previously pending this matter for listing. So after notice matter, Lord. 1100 crore award in my favor, upsetting 37.
Email.
And not a rupee brought in security. And we had previously emailed, but it keeps appearing and disappearing from the list, Lord. It be not fixed. So reply. Last it was listed in March, to be listed in April. So reply.
My lords, may I mention 2 writ petitions which are already.
Say it on the email. It's a fresh matter.
Oh, no, my lords, only for non-deletion, my lords. The date
Okay,
is
just
showed
say
as last 3 days it was deleted, my lords.
Just send an email with, I say NTD.
Email
I've
is-
even got a code. NTD, not to be deleted, and I initial it.
Yes, my lords. Problem.
Only thing is the reason I insist on emails is because then it's tabulated. So then it's easier for them
Yesterday we
to
have sent an email.
process it.
We have sent an email.
I have a tabulation by the end of the day so that I would just say NTD and initial it.
My lords, this is a writ petition filed on 9/7, my lords. Defects were cleared on 18/7. Since 50 days, it is not being tested, my lords.
1 second. I'll tell him. Just send an email. I'll circulate.
My lords, may I mention a matter which is listed today before my lords? My lords, actually,
Wait for the matter to be
Lordship.
called out. Wait for the matter to be called out. Yes.
Like,
No, my lords, we have filed, my lords, the status report, which you have circulated yesterday. And then, my lords, we've also filed the report of the State Health Department. My lords, they've not gone back to work, the doctors, my lords. 23 people have died in the process.
Now, what about the CBI? Has the CBI
Lord,
prepared a
my
status
report is ready, my lord.
We saw your status reports, which were.
My lords, we filed a separate application, my lords, which
Lord,
I think has.
I don't think I have the copy. I'm not complaining. I'm just requesting him, my lord, to give it to me right now. Maybe they have served, it has not reached me, or they have not served, whatever. my lord.
It's not served. It's not served.
Not served, my lord. They have not served on me.
Yes.
Sealed on.
Put it in a sealed envelope and therefore we've.
Sir, sorry.
Okay. Means for the parents. Say one thing, my lord, what is filed by Mr. Sibal is not served upon me. That's what he said.
It is not filed. It's not filed. It's only given to the
But if
court.
they want to say something, why hide something from the CBI? You've already done many things.
I mean, I think let's not get lost in.
Yes, my lords,
Yes,
otherwise
Let's see what this. Let's see the. First and foremost, let us find out what the status of the investigation is.
Yes.
So can you?
Not even with them.
The residence of the, Mr. Solicitor, what is the distance between the residence of the principal of the Ajikor Medical College and the medical college?
15 to 20 minutes it takes, maximum.
It's nearly more than 6.
Check.
consider reading this, my lord, along with this chart, my lord, the report.
Like a clarification on two aspects.
Yes, my lord.
First, what is the time at which TD 861 of 2024 comes into existence? That's the first. So we want to know, as a matter of fact, what is the time at which
The UD.
yes,
Yes, I'll certainly.
UD 861 of
Yes,
2024 comes into
we certainly answer that.
Lord, your lordships had the benefit of going through this, my lord. I would request your lordships to go through.
Yes. We have.
Yeah, just to assist your lordship. I am not adversarial, because we are dealing with a daughter and she is a daughter of each one of us. Therefore, my lord, I am taking it in that spirit. Please have a look at, my lord, this left-hand side and the right-hand side, my lord. Kindly go through it, my lord, with some, my lord, degree of attention. Your lordships, I have gone through, my lord.
Death certificate, yeah. Yeah.
55. Entry is on 250.
उसमें कुछ होगा था.
May I answer? Well, the death certificate was given at 1:47 p.m. Malaj, and the UD entry was at 2:55 at the police station. 2:55.
That is 861.
That's right. There's the second question, Your Lordships.
That's that one.
All subsequent proceedings, whether the inquest report or the CJM's order and all other documents.
What is the GD entry by virtue of which 861 of 2024 comes into existence?
565.
565.
Yes. The entry 565.
And what time is GD entry 565 recorded?
At night, Malaj. 2:55 p.m. Malaj.
565.
565, 2:55 p.m. I can hand it over.
So GD 565
At 2:55 p.m.
is recorded at 2:55.
Yes.
GD? No, GD was
Yes, it's there.
2330.
This is a certified copy, Malaj.
565 is merely a medical
This
certificate.
is a certified copy, Malaj.
Page 64.
It's not a medical. It's an extract.
Extract
I
from
have
the
the copy of GD
Tala
entry,
Police
it's at
Station Daily Register. It's not a
3:30.
medical entry.
No, that 11:30 night. I have the copy.
No, I have a copy too.
Certified.
We've certified copy, we've just given it to the court.
He is still this. 26. He's still this.
No, I know.
The inquest, my lords.
What is the time?
Yeah, if you lords.
4:20.
Just make sure, just, let's not.
Yes. Judicial magistrate,
4:20 to 4:40.
judicial magistrate arrives and conducts it.
And the judicial magistrate arrives and conducts it. He comes at 4:10. And then the inquest is conducted at 4:20 to 4:40.
Inquest is videographed.
And the it is videographed.
Yes. And the same has been saved on a card, which we can.
Mr. Sibyl, also, second question, when was the search and seizure actually carried out?
Just minutes, just. 8:30 to 10:45. 8:30 to 10:45.
Yes.
The photographs had been taken before, Malads.
8:30 in the morning or in the evening?
Evening, Malads.
The body was found in the morning at 9:30.
That's right.
It cannot be
Photographs were
before that.
taken.
It's only when the water is removed.
Once the body was removed, Malads, for post-mortem, then only, Malads.
And by whom? There is some relevance. Therefore, my lord, I would like my learned friend to ask. There is some relevance.
Malads, we have photographs from 12:45 p.m. onwards of everything that happened. We have the original with us.
Now, during the course of the previous hearings, and therefore I think though the investigation is going on, we can share this because you've all said it openly.
Yes, Malads.
That there is evidence that there is a CCTV footage to indicate what time the accused
Yes.
enters the seminar room and what time he's exiting the seminar room.
Correct.
Right? This is
Yeah.
shared with us. Now, obviously, therefore, there would be CCTV footage after 4:30 in the morning throughout the day.
Yes, there
Now,
will be.
has the CCTV footage in its entirety been handed over to the CBI?
Yes.
Yes, we have taken.
Yes.
We have taken.
You have taken the CCTV
taken,
yes.
footage.
But we had to reconstruct the scene because of the distance.
But then, Mr. Solicitor, how do you explain this statement in your affidavit at small Roman 3 at page 14? Just see the last sentence.
My report, my lords?
Yes.
Yes. Page 14, my lords.
Just one para above 7.
Yes, my lord. The SOC was apparently visiting.
Have you handed over, as the Calcutta police handed over to the CBI, the entire footage of the proceedings which took place between 8:30 p.m. and 10:45 p.m.? Because CBI seems to have.
Yes.
What is shared with us
is about 27
minutes.
27 minutes, they say. The
4 clippings totaling duration to 27 minutes. And the proceedings conducted from 17:06, that is 5/6, to 22:45 hours.
Mr. Sibyl said that they have actually conducted from 8:30 p.m., that is 20:30.
I'm just taking instructions.
Yes.
Yeah. Maharaj, yeah, all right.
There are two.
Two separate things, Maharaj. Seizure 8:30 to 10:45. The video of that. Maharaj, seizure 8:30 to 10:45 given. Then, Maharaj, in parts, the videos have been given. In parts, there was some CCTV in hard disk. In parts, completely given, Maharaj. There was some technical glitch. It was stored in part, but given in full. Hard disk is full. And he's made a statement that I've given it.
It's, in this context, I need to, my lord, come in, my lord, here, because there is something, my lord, which, according to me, is very, very serious, my lord. My lord, I want a flap. My lord, we have the forensic examination report. I'll not read it, my lords. But one thing, my lord, is admitted. When the girl was found at 9:30, or I'm sorry, but her jeans were removed and even the undergarments were removed and were lying somewhere nearby. So she was in a semi-nude condition. It is also an admitted position now that there were injury marks on the body and other my lord, areas. Now, your lordships may kindly see the report. Give me copies. And this, my lord, this is a foreign, my lord, your lordships may mark. They have taken the samples. They have sent it to an FSL in West Bengal. And this is the result. And
CFSL.
CFSL West Bengal.
Central Lab, not,
Yes,
not
yes,
FSL.
correct. I'm not on anything else. कहाँ है दूसरा? Do you? हाँ, यहाँ पे लगा. Lord, I have only one copy right now. Please see this, my lord. This is serious, and the CBI has taken a decision to send the samples, collect, my lord, to AIMS and other, my lord, Central Forensic Science Laboratory. The person enters, the body parts are not covered, the late girl is made nude, there are injury marks, and this is the result of FSL. Therefore, who took the samples becomes relevant. Kindly, my lord, have a look.
The injuries are all set out in the inquiry.
See this, my lord.
So this is
Lords,
CCTV camera 16. CCTV.
Which is what is this document?
copy for my Lord Justice Pardiwala and Justice Mishra also. Just give me a minute, I'm just flagging it, my Lord. My lords may just see, my lord, the highlighted part in the flap portion. There are two specimens or two swabs and the result.
Mr. Mehta, we have seen now the further line of investigation which is open. We do not want to comment in it in the open court, obviously, so that the course of the investigation should not be affected.
Correct.
We will give you a week's time. Tell us by next Monday what further leads have emerged during the course of the further investigation. We'd like a status report to be submitted to us by next Monday. Mr. Sibal, it's advisedly we should not be referring to what has emerged during the course of the investigation.
Yes, absolutely.
Let the CBI proceed on the basis of what they are now exploring,
Sure.
the leads which they are pursuing.
Sure.
And we'll keep it now on next Monday. So that
It's a holiday. It's a Tuesday.
Only a minute, Mr. Lord, there is one IA which we have filed, IA 200162. Lord, where, Lord, your lordships were pleased, Lord, require.
Well, before my learned friend says that, I just want.
Deployment, only a minute.
Before my learned friend takes up, just hold on.
If you don't mind, sir, let me just show.
No, it's on the previous matter.
We'll just pass a short order on this.
Lord, the lady.
One second. We'll come back to you in a moment. Let's clarify this part.
Yes.
A status report has been, a status report dated so and so has been filed by the Central Bureau of Investigation. We'll stop. Having perused the report, it appears that the investigation is in progress. So stop. We direct the CBI to file a fresh status report by the next date of hearing. Full stop. List on so and so for considering the fresh status report to be filed by the CBI. So we take it up on Monday for, Tuesday for considering the status report, which would be then filed by the CBI. Let's see what happens between now and because a lot of what has been collected during the course of the last 10 days is subject to further verification. And
we'll also investigate, my lord, who collected the samples because this.
Fair enough.
We will send.
Neither stop you, nor are we guiding the CBI that we want a particular line of investigation to be conducted. CBI is doing it. You have flagged issues in the status report. You tell us next Monday what further emerges.
This also on record, the report of the FSL.
We'll return this back to you. Why should we retain it right now?
Whichever way, my lord, comments.
We'll return that back to you.
Just one more thing. Just my lord, out of my lord, the lady.
First, we'll retain only the second status report on the record. The rest of the papers we'll return back to you.
My lord, there are 3 lady companies, my lord, of CISF. My lord, they are not providing the accommodation to them. They have to travel, my lord, from CISF camp, which is 1.5 hours away from the state. My lord, thereafter, my lord, there are several things which we have requested. It is order dated 22nd. We are, my lord, almost 15 plus days down the line.
Well, as we have provided, in fact, if your lordship looks at our note, we have provided all that they wanted us to provide, everything that they wanted. Just give it to me.
The three companies of women constables
and
who are guarding the Adipur college,
women.
Where are they presently housed?
Well, that's I just show to your lordships, my lord. Please. Kindly see, my lord.
Look, can I have at least that?
Yeah, we'll just give it to you.
Yes. And I'll also share what is not provided so that you,
Just give it to you.
at least henceforth, you could, instruct
Kindly
them
see,
to
madam.
provide.
Kindly see the accommodation.
Yes.
KMCP Day School, 2.6 kilometers, 13 minutes away. One company proposed things, one company 54 women personnel. Indira Maitri Shishu Kalyan Hospital, 6 minutes away. One company 54 women
No,
personnel.
when?
These
Because
have
we
been
have been
provided.
hammering since
Then
2 weeks.
3 flats in RMO quarters within so-and-so, on-site 20 for 25 personnel. Currently, 20 CIFS personnel are staying in 2 flats of RMO quarters within
Within the hospital.
the hospital, and the rest of the CIFF personnel are commuting from 12 kilometers away. And the school and Indira Maitri Shishu Kalyan Hospital were undergoing construction, and therefore these are identified by the CISF themselves, Malal. So we put them there. And most of the state police officers deployed by so-and-so come from far-off places like Police Training Academy, Howrah, which is 22 kilometers away, Bodyguard Lines, which is 12 kilometers, and Police Training School, which is 10 kilometers. So, Malal,
Lord, this is my instruction
and
as on
our status
10:30
reports, Malal, sets out everything.
as on 10:30 today, my lord, this is my instruction.
No, but we are telling.
Kindly have a look at this, my lord.
This is, this.
We should not be fighting on this, my lord. The CISF,
And therefore, exactly.
we requested for
once I have
handheld metal
stated-
detectors. We requested for door-size metal detectors. other
Everything is
equipment.
provided.
They provided that after 2 weeks, but this is
No,
still
no,
not
we
provided.
provided there.
Let's have a look at this.
Just a second. What is now remaining to be provided? Mr. Solicitor,
That's
you have
what I
seen
am-
this. They say for housing one company of women personnel consisting of 54 persons, they have provided at KMCP Day School, which is 2.6 kilometers.
Kindly have a look at 10:30. At 10:30, this is
Well,
yet.
let the registrar of the High Court go and see, Malal.
Yes.
Let 10:30, my lord, this is at 10:30.
Let him go and see.
I don't want, my lord, I'm not enjoying.
Can we can we look at this for a moment, please?
Yes, Lord.
Accommodation for one company provided in 3 locations as below. RMO Quarter, Ajikor Hospital, 20 persons. KMCP School, 40 persons. Indira Maitri Sadan, 30 persons. Likely to be handed over by evening today. 2 companies are
Yet to be provided
yet to be
accommodation.
provided.
Some security gadgets are provided, some are not provided. Lord, I'm not gaining anything by pointing this out. This is what is needed. Lord, if some incident takes place, Lord, I stand responsible now for the security, the CISF.
Just one second. Mr. Sibal, you just check, Ms. Astha Sharma, you can check with the officers.
Yeah,
In your statement, where you have said one company, 54 women personnel,
yes.
that covers one and the same company,
Oh,
which has
Either
been
one
provided
company
at
or 54 women
KMCP and
personnel.
Indira Maitri or Shishu Kalyan
no, Malal, it's
Hospital.
one company / 54 women personnel.
Right, but the same one company.
Yeah.
But now, as of date, they have deployed 3 companies. So the other 2 are yet to be provided by you.
My Lord, when
One
this is
second.
provided?
One
This
here,
is
Malal,
provided
kindly see
yesterday.
Indira Maitri, that's the other one too.
Yeah, that's the second one.
That's the second one. It's in Indira Maitri, Malal, which is
So
1.7
we are trying
kilometers.
to tally what they have handed over with what you have handed over. What they have handed over suggests accommodation for one company provided in 3 locations, which includes 40 persons at KMCP and 30 at Indira Maitri Sadan, and 20 persons at RMO Quarter. Now, that indicates that only one company is taken care of. There are other 2.
According to us, no.
Persons plus.
Just ask the registrar to go and
Why
check.
don't you,
One
can,
company, why register?
can we suggest this? Why do we have to ask the registrar to do all this?
Because they are contesting.
An officer of the state government and an officer of the, a senior officer of the CISF.
We have done that,
Not one
On
company
ground, we have
can-
done that. They are not wanting, in fact, Malal, on the ground, the story is different. Malal, what can we say, Malal?
But one
Alright,
company,
aisa likh
is
lijiye.
90 individuals,
Okay.
90 Lord, officers.
A total of 3 companies of CISF personnel has been deployed for the security at Ajikor Medical College and Hospital. Full stop. Mr. Kapil Sibal, the state of West Bengal has in its submission indicated that provision for housing the personnel has been made thus, colon, ये in case में page 1 को tabulated chart ले लीजिए. Prima facie, it appears from the above tabulation that the prima facie, don't say prima facie, it appears from the tabulation. In the statement which has been placed on the record by the union government, on the other hand, it has been indicated that accommodation for one company has been provided in 3 locations, namely at bracket 1, RMA quarter dash RG Kaur Hospital, bracket 20 persons, 2, KMCP school dash 40 persons, semicolon, and bracket 3, Indira Matri Sadan, 3, bracket 30 persons. And that the premises are likely to be handed over by the evening today. Full stop. In order to obviate any logistical difficulties, we direct that an officer of the nominated, a sufficiently senior officer of the Home Department nominated by the state of West Bengal, and a senior officer of the CISF at the spot shall jointly liaise so as to ensure that all the 3 companies of the CISF personnel which have been deployed at the spot are duly provided for accommodation in the vicinity at par with what has been stated in the tabulated position set out above. Full stop. Next. In the event that any further full stop arrangements have been made for providing 6 buses, 4 trucks, and 3 light motor vehicles. Full stop. The 2 officers shall ensure that all requisitions, that necessary requisitions which are made by the CISF are duly complied with by 5 p.m. today. Full stop. Necessary gadgets for security purposes shall likewise be arranged no later than by 9 p.m. Today.
No, but that's,
As a matter of fact, this is also provided, must have been provided tomorrow, yesterday or day after. I don't wish to trivialize the magnitude of the problem I am dealing with.
One further thing now.
but I have 3 issues that I wish to place before you.
Before we hear you on those issues, Mr. Sibal, what steps have been taken by the state of West Bengal for, because we had said that pending the finalization of the recommendations of the National Task Force, we would like the state of West Bengal to immediately put into place necessary measures which would bring into being some sense of security and
We have got a report, Manoj, from the health department.
and provision of adequate measures for the doctors, nurses, and the paramedical staff.
Yes, Manoj.
Status report.
Status report that we have filed, Manoj.
The health secretary.
Make a prayer, let the competence of the autopsy service be also not within the purview of the investigation. And also they had offered money so that they can, my lord, speak in tune of the police. This should also be within the purview of the investigation. That's Muhammad Abbas.
Look, we need not pass any separate order because what you are saying is already a part of the status report. The CBI is looking into all these aspects.
I appreciate just one thing, that this postmortem could not have taken place after 6 o'clock in the evening. There are standing instructions. Everything, my lord, will just kindly take the postmortem report once and just give me 2 minutes. I will show your lordships how this entire investigation has been compromised. After 6 o'clock in the evening, a postmortem cannot be conducted anywhere in India and in the state of Bengal when it is a rape and murder. There has to be a noting of the civil surgeon on the postmortem report that the Deputy Commissioner of Police or the Commissioner of Police has certified it. Then it has to go to the superintendent. Superintendent certifies it and then sends it to the postmortem doctors. These 3 postmortem doctors, one of whom is a professor of forensics, my lord, knows this, but still, what is the reason? The reason was to get rid of the body. What Justice Patiwala was continuously asking, the GD entry number 576. I will ask them to show Form 27, and I'll answer Justice Patiwala's questions in 1 minute. Form 27, please. Form 27 is the first information report. In the first information report, there are various columns. Column 3 C2 gives the GD entry number.
Column C.
C2 gives the GD entry number by which the FIR was started. The FIR was started by GD entry number 577. The UD case was 576, as pointed out by Justice Patiwala. It was registered at 11:40 in the night, 45 in the night. But in the history,
That was better the last time also.
in the history, in my last 27 years in my career, I have never come across a case where seizure takes place prior to the lodging of the FIR.
The FIR has been registered at 23:30 hours.
Yes,
Yes.
now, there was a previous FIR.
Along with,
The FIR has been suppressed.
If you see,
I will show it,
3 doctors sign off on it.
Anok,
I will show on the,
6:10 to 7:10. Let him say.
Let him complete his submission.
Dead body arrives, 6:10.
Mr. Counsel, please complete your submission. Yes.
my lord will kindly take once. My lords will kindly take section.
Just tell us on the facts, what you're saying.
My lord will kindly take the postmortem report and compare it with the UD case which was started. In the postmortem report, the lordships will see whether the clothes of the victim were produced before the postmortem doctor. The entire the jeans, the top, the undergarments, everything was produced or not. Because as per I'll show the notification, they have to be sealed by the postmortem doctor and handed over to the investigating officer. If your lordship sees in the top whether the clothes were sent to the investigating officer of the UD case by the postmortem doctor, I will kindly ask them to just give a copy of it.
Of the postmortem.
Postmortem. And allow me to
We've handed over the postmortem.
We have seen the postmortem report. Just show us the postmortem report.
We've handed it over.
Either the state of Bengal or the CBI. We saw it last time, but since he's making a point, let's appreciate what the point is.
So the parents wanted. They had a list of demands, including the parents.
postmortem report doesn't even say at what time it is conducted.
Yeah.
Give it to us.
I'm sorry, that too.
Yeah. It says that at the time, everything is there. I don't know why you're making these.
Please tell us what the time of death is.
It's
Just
a
1 second.
condition of
Take out copy.
the subject, Malas, your lordships will find on the left-hand side.
lordships will kindly see at the top.
Right.
First will be the videograph. Conducted by whom? No designation. Who is he? From where did he come? Nothing. Was the
Conducted
CD
by
on a
Sekhar.
rewritable CD or was it a non-rewritable CD? It has to be mentioned on the first line of the postmortem report.
The judicial magistrate was present during
is
postmortem
immaterial.
call for his report.
All the 3 doctors are part of the,
5 female doctors were present.
all are part of the North Bengal lobby.
Family.
For by the family.
Don't discuss such things here. Please.
My lord will kindly see the second line. It has to be at 4 degrees centigrade.
The postmortem report refers to Tala PS UD case number 861,
Yes.
dated 9 August 2024.
Yeah.
My lord, that's where the mystery lies, because between 2:30 in the afternoon, when they say the GD entry was lodged, that is 5:65, and 11:30 in the night, there are only 10 GD entries in Tala police station. Lordship should kindly appreciate that. Between 2:30 and in the afternoon and 11:30 in the night, there are only 10 GD entries. Or was this entire thing manufactured? And Maharaj, this started way back in 1953. It was the first case in Bengal where GD entries are manufactured.
Know that, what he's saying. everything will be clear. The judicial magistrate witnessed all this. Call for that report.
Not on magistrate or these.
I say it makes no difference.
Lord, give me a minute.
My lord,
Please have a.
every police station has a natural death.
No difference, he said.
Sorry.
Lord, kindly have a look at left-hand side bottom, the finding. In the case of wounds, not note whether there is any indication of wounds being homicidal, etc. Then the report is death was due to effects of manual strangulation associated with smothering, as noted above. Now, please see manner of death, homicidal. There is a medical evidence of forceful penetration, insertion in her genitals, possibly of sexual assault. And see, my lord, the FSL report. My lord, I have marked, my lord, two,
CFS.
my lord, seized items.
Just give us that.
Given that. I'll just, Lord, in the second swab, flag, I'm sorry. In the second swab, Lord, second flag, please see B, the observations. In the second flag, please see B. First, my lord, please see the first flag. Lord, I have marked 2. Exhibit U1, Exhibit U2. Correct, my lords?
Right.
Does my lord Justice Pardiwala and Justice Mishra get? Yes. Now, kindly come to the second flag. And please see, my lord, the findings of this laboratory. From the above observations, it is concluded that, then B. B. So and so, I am not reading it. Please see the underlined portion, my lord. Rest. The CBI will send this again for retesting by AIMS and some other level.
You have said in the status report that CBI is.
Malad, now,
Take the postmortem report once.
Malad, now.
Because it is shocking. Kindly take the top column and see whether all the wearing apparels were produced before the doctor.
Just 1 second, let's see that.
Of how it has been tampered.
There.
And the undergarment.
Do you have a copy of this?
No, I don't. But now compare it with the UD case.
Mr. Solicitor General,
Yes.
officer is present.
Yes.
Just ask him to take this report in his hand.
You have.
The first line on the top. He doesn't want to disclose, no problem.
You have an answer, you can read.
No, if it is coming in his way of investigation, he may not.
No.
We just want to know.
He knows he can also answer. But first line,
Just read it in your mind. The very first line,
your lordships are on this line, Manoj.
you have this report, right?
Correct. I'm just, to understand
Just
this, we
give
are
it.
assisting your lordship with.
Correct. The one which we have marked in red.
Correct.
No. Sorry.
I'm sorry. Therefore, Manoj, I was also a little confused.
Sorry. Wait a minute. I'm marking it.
Yes,
Now it is bracketed with pencil.
correct.
Have they looked into this? Is it in the form of some interpolation or something? Did you get it?
Yes.
Lord, that is under investigation. The time difference is a matter of investigation.
You
That's
have
what,
said that in your status report.
Yes.
and
Therefore, page 9 of your report
Look, sir,
Roman 4.
what fell from you, some of the aspects which you have highlighted are the subject matter of the investigation by the CBI. So obviously at this stage, when CBI is looking into it, we should not be commenting on
We
it presently.
appreciate that there was a previous FIR. That Lordships kindly just take two sections and give me just 1 minute.
How do you say that there was a previous
I'll
FIR?
explain to your Lordships. Lordships will kindly take section 173 of the BNNS of the new code. It says on receipt of an information, an FIR is to be lodged. Now, what does 176(3) state? 176(3) of the BNS states that if an offense is above 7 years and a forensic expert has to be called for, on the receipt of an information regarding an offense, so there has to be an FIR. Without an FIR, 176(3) cannot come into play. The forensic team was there in the afternoon. So they could have only been called under section 176(3). So there has to be a previous FIR, because if there's no FIR, then you can't call the forensic team.
It's okay.
We are being led to believe that the first registration of the FIR takes place at 23:30 hours.
That's right.
There was a previous FIR, which was there. Now, Lordships also appreciate one more thing.
possibly he says there has to be. There has to be, not there was. Possibly, as I understand him, he said there has to be a
The
previous.
forensic team cannot come.
Otherwise, forensic you can't call.
There was an FIR
176
which has been
status.
suppressed or has been destroyed. By whoever, I do not know.
Yeah, yes. Okay.
Kindly take the PM report once, kindly take the top
Look,
line.
at the same time, we have now looked at the status report, we have looked at what has been produced by the other side. There are UD entries. One is 542. Sorry, GD entries.
GD entry.
GD entries, 540. 1 second. 542 first.
10 AM. Well, that is also wrong.
That's a matter of that is a matter of investigation.
Has to be at the.
That is a matter of investigation. Today, on the record that has been handed over, and CBI has also referred to it, is 542, 565, 576, And then
555. Then 576.
565, 576, and then
577.
and 576 and 681.
No, then 577. That is the formal FIR.
My lord, leaving the brief aside, the problem is, my lord, we are dealing with, my lord, whenever rape and murder takes
These
place,
discrepancies which you have pointed out, CBI is alive to them. And on the basis of these discrepancies, CBI's further investigation is going on.
Yes, let them investigate.
The sample. Now the vaginal wash, the blood had to be preserved at 4 degrees centigrade. These three doctors purposely did not preserve it at 4 degrees centigrade. Now that sample might be contaminated. It has to be preserved at 4 degrees centigrade.
Well, if the CBI,
therefore, I say that there
doctors
is
are-
something very serious. I'll tell my lord, your lordships, in case of a rape and murder, the first 5 hours are crucial. Well, the first 5 hours is the period where you have to cordon off the area. You cannot have an ingress and outgress. Whoever wants to come and go, they take pictures, photographs, evidence is destroyed. And thereafter, after 5 days, if we enter the scene,
That's why
we have our own challenges.
We asked, the first question which we asked was, has the CCTV footage between 4:30 in the afternoon onwards been handed over to
yes,
the
it has
CBI?
been.
They say it has been.
Well, we've got
No,
the
no,
document of
27
handing over.
CBI says that they have it. Let them look into the.
27 minutes only, not.
No, the entire, we've got
Just
the
a-
handed over document.
There is a little bit of a confusion on this, Mr. Solicitor. What CBI has been handed over, which you have also said, is about 23 or 27 minutes
20.
of 27 minutes pertaining to the actual search operation which takes place and the inquest which thereafter has taken place. We wanted to know whether you are in possession of the complete sequence of the CCTV between the time that the accused leaves the hall
Mullah, I've
and
got the document.
events
But
which
my lord,
take
the
place.
CCTV
over
will
document.
only show the accused entering, etc. Here,
No,
the
no,
crucial-
Who else, Mr.
Crucial
Solicitor, who else entered after the accused had left?
Mullah's handed over,
dealt with the
over memorandum.
Look into these aspects.
Mullah's-
We will.
Tell us on the next date of listing, because these are obviously, now that some leads have emerged, we'd like you to further investigate and come back to
Mullah's,
us.
I just want to mention,
But only one.
can I have a word for this? Can I have a word?
My lord, may I just speak on behalf of
Only-
the student?
Mullah's,
Only a minute, ma'am. I'll just.
Yes,
in the
sure.
date.
this would go on till.
Different.
It's all there. Mullah's, I just want to,
Lord will kindly-
May I just say
Mullah's,
two
may I?
words?
Whether the X-ray plate, because my lord, the body was found, the legs were found at a 90-degree angle. Now, 90-degree angle cannot take place without the hips being broken. My lord will kindly see in the post-mortem report whether the X-ray plates have been handed over to the CBI.
Lord,
Whether the X-ray was actually done or whether the X-ray plates were handed over.
we've got the photographs with us.
Mr. Solicitor, just one question from your officer. When the body is dispatched from after the inquest for the purposes of the post-mortem, you have that letter by which the body is dispatched for post-mortem.
Yes, my lord, it is there. Form number
Arey, wait a minute.
5363.
Once again, how will you
Let
have
me
it?
have-
We are
I'm
asking-
saying, I'm seeing the form number.
Obviously, we're saying it with a certain purpose. We want to see that.
It will be a long.
I'll check up, my lord, and.
He knows everything.
Yeah, it is there. Because it was shown before the High Court. Before the High Court, I argued.
Can you just, 1 second,
I don't have it. It was before the High Court. It was argued.
just 1 second. Let's not get into these bickerings. We have flagged a document. We want to see that document. Do you have the document here?
Yes, I'll just want to check. Immediately. The body was handed over from in.
Ms. Astha, do you have the documents?
We just were trying to see. But in the meantime, I just
All the
mentioned.
dead body chala.
Lord, in the meantime, can I
Just 1 second. So only deflect We are on one particular issue. Let's seize that issue and then
Yes.
see if there is a satisfactory answer.
Yes.
Otherwise, CBI will look into our query by the next day.
Only
But there is also an antecedent aspect to what the Lordship. Yes. Yes.
Till they find out, my lord, your lordships have kept it on 17th. 17th. Can it be on 18th? 17th would be miscellaneous day. That's on.
We'll get a little more time.
Yes, no, miscellaneous day has its own problems, your lordship knows.
But let them
18th.
investigate it.
Mr. Sibal, do you have it?
Mulaz, I only have this that is handed over, dead body challan that's handed over. That's all I have. To the family. Yes, to the family.
But not the family. It was from the
Come on now.
person who does the UD.
Let my lord the Chief Justice see
Not
the
the
document.
This is the blank one. It would be like this. This is blank one.
I'm sorry, Mulaz. No, who can read
This is
this?
the blank one. It would be like this.
This is not what we are asking for.
No, I'm just saying that's all we have at the moment.
Disposal order accompanying corpses sent for cremation. This is when the body is given to the parents for cremation.
I cannot find the document immediately.
We are just trying
This is the only thing we have at the moment. That's all I can say, Mulaz.
Because when the body is dispatched from the post-mortem after the inquest, surely the doctors who act on that and do the post-mortem would first look at what is given to them.
We just look at it.
It would be like this.
No, you just have the format.
The blank form.
All right, let's see the blank format. This is a challan for use when a dead body is sent for examination.
Yes.
Where is that filled out challan?
Well, it's part of the case that because it was shown in the High Court.
You wouldn't know it. How? Let the CBI say. We asked the state of West Bengal whether they have it here in the court. Let them give it to us.
It should be part of the case diary. That's all we get.
That is not given to us.
Form by which you handed
That
over.
is not given to us.
Not be given to you.
That's what my answer.
Yes, it's not the file given. That's very important.
It's not in the file which is given to us.
Ms. Sharma, where is a challan when the dead body was sent for
Figure out, Mulaz, where
for
it
the
is. We're trying to
post-mortem?
figure out. Huh? See, let's not state something unless we are absolutely sure what it is.
Month later, and they're still figuring it out.
They are saying it was shown.
It's of very crucial importance because this form also has a column which says remarks noting what clothes and articles were sent in with the body, which means that together with the body, other things which have been then seized,
Must have been.
and other material is also sent to the doctors who conduct the post-mortem. We want to see that.
It was definitely a part of the CD when I argued the matter before the country.
Part of the case diary.
The last column.
Are you sure?
Make sure. Have given, maybe. Or may have given, we don't know. They say they have not seen this and the file handed over to the CBI does not contain this document. But it appears from the argument of my learned friend that it exists because according to him it was shown to the High Court.
No.
Without this, my lord, the post-mortem doctor cannot accept the body.
Post-mortem doctor will not carry out the PMR, the post-mortem, and he will not accept the body because first and foremost he has to have a request in the challan that please, this body is being sent for the purpose of
On the
examining.
challan, he gives a seal saying accepted.
Mullah, your lordships will give us time. We'll try and place everything before the court.
There, Mr. Sibbal.
It's not, Mullah. We've checked it up. It's not there.
And CBI says that they also don't have the document under which the body was sent.
To us, that file does not contain
What
this
I'm
document.
told, what I'm told is that the CJM came, Mullah, and he filled it up himself, and there's no separate form. That's what seems to have happened.
Was the postmortem carried out without a
It's impossible. It's impossible.
without a formal dispatch of a request to the postmortem doctors to carry out the
Not
postmortem?
just an administrative form, it's a statutory
Mullah, I
form.
don't have that information. I can only
Just have this postmortem report in hand. You
in
must
hand.
be having
Postmortem
it, right?
report. Yes, we have it, Mullah.
Now see the third column.
Yes.
See the third column on the top of it.
Third column.
Constable by whom brought.
Yes.
So this constable is supposed to carry this.
This challan.
Okay.
He is supposed to carry this.
Yes.
And if there are any relatives accompanying, the names of those.
Sure. Yes.
Now, it has been struck out.
Blank. That's blank.
So there is no reference of this challan for use when a dead body is sent for examination. You need to explain.
Yes, yes, certainly, Mullah.
So tomorrow, if this document is missing,
Yeah.
then something is happening.
Yeah, sure, Mullah. Sure. So we'll find out, Mullah, as to why this is brought. This is why it crossed.
বইটা পাঠাবে
To that effect, Mullah, we'll file the affidavit to that effect, Mullah, so that we can't be making statements, Mullah, in this fashion.
Solicitor, please do, if you need that, and that has not been forwarded to you, CBI should make a requisition for that.
No, certainly, my lord, we will have to end it, that fact being absent in the
Also, this
postmortem
is in
report.
light of the fact that learned counsel says that when the matter was argued before the Calcutta High Court, that was part of the CD.
It was one of the video, it was live, streamed live. The lordships can call for the particular link and see it for your lordship says that it was shown. In fact,
But in absence of mention in the postmortem report, the possibility of it having been created subsequently cannot be ruled.
That's subject matter of investigation.
Investigation, I'll not say anything more.
Investigate.
Somebody has created
What has been created subsequently?
All right.
Nothing has been created.
All right. Should we
File an affidavit,
we'll
Mullah.
move on to next
Yes.
Tuesday after this is
Yes,
over?
Mullah.
My lord,
We have-
Wednesday, my lord, Tuesday is a miscellaneous.
All right, Wednesday. Tuesday is miscellaneous.
Lord.
We'll keep it on Wednesday.
Lord, may I?
Wednesday, no. Wednesday.
One
18th.
second.
Well, Wednesday is 18th, that PMLA matter starts on Wednesday. Mullah, please don't have it on Wednesday.
All right, we'll keep it on Tuesday after the miscellaneous board is over.
Yes.
So may I just say
Lord,
one
may
thing?
I say-
One thing.
Mullahs can
No,
be.
but just one thing. So we are 1 month down now since this death took place. We do not have any clarity about the estimated time of death. I thought the postmortem report, which normally says, may not be exact, approximate, but we still don't. What is the West Bengal's case as to when this death took place? I would imagine they would say it's before 5 o'clock
Clarity
sometime.
on that. There is some clarity on that.
Yes. In the CBI.
There is clarity on two aspects.
Yes.
One, when the body was discovered,
Yes.
there is some clarity on when the body was discovered. And there is some clarity about the movement which takes place in or around the room where she was staying for the night, where she came in late after the
But then the person,
stomach contents also reveal that,
she had a meal.
yes, that's right.
No, so there should be one more aspect then. The person who actually first discovered the body or learnt of it should actually be the first informant. And the time of his knowledge should be the time of the first information report. So the delay starts from there.
There's a delay of almost 14 hours in recording the first information report. It's very clear that there's a delay of about 14 hours. At least 14 hours.
14 hours, at least, yes.
My lords, if I may, with regard to the other investigation that is happening, with regard to the financial irregularities.
That CBI is investigating, but right now that is...
Exactly, the CBI is
Obviously, we have started that investigation, but we are on far more pressing issues at this point of time.
My lords, the trouble with that, the difficulty with that, and I am for those 25,000 doctors, which include, in fact, whistleblowers who have placed and are assisting the CBI and have placed documents with the CBI. Now, some of us are still in RG Kar Medical College, some of us are in the health department, and there are threats, frankly, my lords. So what we are seeking is that, my lords, just seek a status report for next time, because the two are inextricably connected, my lords, as the High Court has found, in fact, that the two are connected.
The nature of the link between the two is itself the subject matter of the investigation which is going on. Let's not say much more than that.
Absolutely. So we are not seeking that we see the status reports, of course, my lords. What we are seeking that my lords keep track of that.
Three issues.
Your Lordship,
I also did not
may I
deviate.
just say?
My lord, only a minute. Mr. Sibal was to explain why the administrator or the superintendent was immediately accommodated somewhere else. But I did not start with that.
Lord,
He was to explain that.
Your Lordship had told us to give the names of the miscreants, some of the miscreants that we know in RG Corps, and give them in a sealed cover. So, my lords, may I just give the names in the sealed cover to your Lordship?
Of those who vandalized the...
Of those who vandalized, who came to the scene, even tampered with the scene. So, I'll just give this sense.
One second.
Well,
Before you
nothing was
make a statement tampered with the
fair, my
scene,
lord.
Yes.
please be a little careful. Tampered with the scene is a very strong word to use. The vandals tampered with the scene.
I'll just show your Lordship.
Please allow the CBI to investigate.
I'll just show your Lordship 3 photographs. Can I just show in sealed cover 3 photographs? That's all.
You want us to make any observation that the crime scene was tampered with? The investigation
Your
is going
Lordship,
on.
just look at these photographs. We've got them for your Lordship. And give these names, please. And give the names to Mr.
Don't know what.
For whom? To DSG for the duties.
The junior doctor,
the West Bengal front.
Well, the CBI has till date not said that their seal has been broken.
Sorry.
I don't know why these statements are being made.
See, I'm not saying
The
anything.
CBI itself does not say so, but you are saying
Please give me a second.
you can't.
My lord would
just
see
can't make
this
statements
was-
at random like.
What time are these photographs taken? What time are they taken? What is the
My
date?
lord, this is at where the body is there. Annexure A2.
Time.
My lord, this is on that
We're
day.
having a
On the day of the incident, and I've given the name of the person who is, and very many other persons who are unauthorized, who are going to that place. Then your lordship would see page 2, annexure 3, where I've given other persons. They are all walking in and walking out as if it's not a scene. The very next day, my lord, just look at page 3, annexure 6. They break.
Our work a little more challenging. She is right.
One second. And last page, which is most important, my lord, just see the last page.
We saw the last page.
So what I'm saying, if the manner in which it is you can make out that this has been redone at a later time. Otherwise, there would be struggle. There would be some signs. There would be some stains. This is completely botched up, and the very next day they demolished.
Right, you've made your point. I think
Next
he has also
2
pointed out
rooms.
something.
But
Can you
what was, my lorry friends not able to explain it. What was that? That was the toilet, which had a basin and the tiles on the wall. Now the entire tiles have been changed and the basins removed. So even if you do the luminol test now, which is after washing of a crime scene, there's a test called the luminol test. Even if you do the luminol test, you will not come to know whether the accused actually went over there to wash his
Who has
hands,
said tiles have been removed?
It's a
And
part
Lord,
of
we are also
on the
asking
10th.
I don't know what.
that
And because the luminol test now fails, because the entire tiles and the thing was changed.
my lord, 2
May I?
Serious investigation.
Millard, may I make just a
my lord, 2 other
May I just-
requests. One, CISF is letting people go to the emergency room without checking the iCards because people say they are doctors or they say they are staff. Now in West Bengal, about 1 lakh odd people are civil employees who are over and above the police. And therefore, they seem to have identification cards without any verification. So they walk in and out. People who say they call them civic volunteers. Now that's dangerous. And this person was perhaps one of the either touts or a civic volunteer who's
He was
gone
a
in.
civic volunteer himself.
Yes, that's what I'm
Huge
saying.
Jesus.
They may call themselves whatever, but they have no identification.
Because
no
we are the one who arrested him.
This is going on because the moment that they say we are doctors, people are going.
CISF personnel are in charge of the security of the hospital.
Remove
Obviously, they have to take adequate measures to ensure that any person who is seeking to gain access to the emergency ward, it can't be a random access to anybody. Otherwise, how are the doctors protected? So CISF has to tighten up the measures on who can access the emergency wards also.
Correct.
It can't be that any random civic volunteer can have full access to the entire emergency ward, which is where all the doctors are on duty at critical care facilities in the hospital.
That is being done. That is being done.
So please ask the CISF company to ensure that
it is ensured. I can assure your lordship, it is ensured
that
she is saying
all necessary security and safety precautions are adopted for protecting the doctors, especially
And
those
what-
who are on duty at RG because they were there, right?
My lord, one more request. On social media, photographs of this victim are being floated. These may be taken off. I'm requesting if that a general direction
respect
can
the
be
dignity
given.
of the.
Because this is not
Of course, it's
permissible
not possible.
anywhere in the world that it should be sensationalized or what it.
But the photographs which you have produced before us at random.
Because we were there, all of us were there, many of
taking
us,
pictures.
So
10, 20
Photographs are everywhere.
were there.
you mean to say you took the photographs?
My lord, I mean, several persons.
Where did
just
you get those
to-
photographs from?
The scene of crime was not cordoned at all. People were
But
walking
tell us,
inside.
therefore you took those
It
photographs.
is our suspicion that next, the 2 seminar rooms was where the crime may have
You are
happened.
also showing
Which
all
are
these
being
photographs. And
published.
how do you get possession of these photographs?
My lord, the fact is that they are being circulated. And this person, one of the persons, I've given the name of some 10, 20 people who are the main miscreants and in this hospital. And my lord, all other hospitals there are having this issue.
All council, we are going to direct that the photographs of the dead body of the deceased have to be forthwith removed from all social media.
Absolutely.
Correct.
Because
Absolutely. We agree entirely with that.
damage has been done by
Yes,
the
yes.
circulation of these photographs. It said that all social media posts
Mullah, even the seizure list, Mullah,
circulating
Lord, the only one aspect on
photographs
this.
of the dead body of the deceased shall forthwith be removed to ensure the privacy and the dignity of the victim.
Lord, direct.
may I add
Not
this,
something more than
including the seizure list, because there are issues of privacy involved. Mullah, seizure list includes all the garments, all the other things, Mullah, with photographs. All this is being circulated. Mullah, therefore, all this must stop.
Obviously, that leaked when you were in charge of the investigation.
No, not at all. Just the opposite. Published on 4th of, Mullah, it's published on 4th September when the hearing is on 5th September.
My lord,
Only add one thing.
This is not fair, Mullah.
We'll see what happens on the next occasion.
Mullah,
There's a form,
Form de do zara.
police.
5-3.
One addition, my lord, I would request. My lord, only one addition I would request. Direct and indirect photographs, because some of the photographs I have seen, the girl had a specific hairstyle. So they remove the face, but the hairstyle is quite recognized.
During the course of the hearing, it has emerged that during the course of the hearing, the court has been apprised of the, into invert commas, challan for use when a dead body is sent for examination, into invert commas, complete. Full stop. the Solicitor General, on the instructions of the investigating officer of the CBI, states that the above challan, duly filled in, is not a part of the file which has been handed over to the CBI for investigation.
Sure.
Stop. Paste with the above. Paste with the above. Is faced with the above, comma, it has been submitted by the Learned Counsel appearing on behalf for the original petitioners before the Calcutta High Court.
One of the petitioners.
Appearing, saab ka naam likh lo. For one of the petitioners before the Calcutta High Court, that the form was, as a matter of fact, produced before the Calcutta High Court during the course of the hearings. Stop. The form is unavailable with Mr. Kapil Sibal, Learned Senior Counsel, and Mr. Asta Sharma appearing on behalf of the state of West Bengal at the present stage.
I just want to know whether it's form 5370.
5371.
I have 5370.
Sir, can I just see?
What does it say?
I'll be able to tell you in 1 second.
It says, Malad,
changes now.
formation of.
It is in another PRB.
No, that's for cremation.
No, not for cremation.
Yeah,
I have 5370 here, Malad.
Show the. Can you show it to us for a second?
Yeah.
वो दिखाइए जरा.
No, give this.
नहीं, ये अलग है.
The identity, Malad, of the
covers the one.
deceased. Name of deceased.
Number 53.
53 under
This is
174.
form number 54.
We wanted form 54.
54.
That is WB form number 5371.
This is form 53. Malad.
Even their file doesn't have, Malad, that's.
वहाँ पर आपने जो into inverted commas
justifies by saying that we
वहाँ पर लिख लीजिए into brackets WB form number 5371. The
पता कर लो.
PRB form number 54 dash VDA rule 282.
Milord, these
A copy of the form, a copy of the form duly filled in, comma, which shall be produced before this court on the next date of listing.
Milord, we have complaints.
My Lord,
1 minute.
also to produce form number 5363.
What is 5363?
That is the case, when in a case diary, you have 172 in the old form, my Lord, start date, end date of an investigation for a particular day. From there, your lordships can call out what exactly happened in this case after the investigation started. From there, your lordships, the first entry has to be the UDA case number because it was lodged at
That is form 5363.
5363.
Do you have a pro forma of the form?
At the moment, I don't have it. But I can hand it over
Case
to...
diary would have been handed over to the CBI.
Please do that. Please do that to me. I'll hand it over to this.
Malad,
It says case diary...
Look at form 5363 and keep it ready on the next date.
536.
5363, sir.
Just keep it ready.
Three.
We'll examine it on the...
Find out.
Milord, various
My lords, one last thing that
colleges-
my lords may record.
various colleges. One,
yeah.
National Task Force will be doing its work. In the meanwhile, CCTV cameras and distress call systems be installed in all hospitals. So that should be implemented firstly, my Lord. Secondly, my Lord, I have a suggestion that there should
We filed the report, Malad.
be connectivity between all hospitals and the nearest police station. That's one. And secondly, my Lord, whenever a complaint is filed, why should a victim have to go to the police station if there is any incident of violence or harassment? The management of the hospital should be the complainant. That's second. And thirdly, my Lord, we should go beyond the CCTV cameras. There should be wearable devices, as a badge or on the wrist, where if there is any violent incident, that should be immediately, that should lead to an alarm.
That we have asked the committee specifically to formulate it.
That's due tomorrow.
We expect the committee to come out with its
My lords, that's due tomorrow. Could that be placed then on the next occasion? Because our doctors, my lords, are working, they're back at work, and they are not feeling safe.
Well, they are not back at work.
My
One of the issues I've raised, Mother.
25,000 doctors are back at
So,
work.
Sibyl, we would expect the state of West Bengal to put into place, even without waiting for the report of the National Task Force,
My doctors are.
basic measures for ensuring.
We have done it, Mother. We've done it already, Mother. We filed an application.
Your status report merely indicates that funds have been sanctioned.
No.
Not indicated what steps have been adopted on the site.
Report, Health Secretary says all that, Mother.
My lord,
Mother, can
my
I,
lord, the CISF,
There are goons in the
Mother,
hospital.
can I have the liberty, Mother, at least to address your losses for 5-7 minutes, Mother?
That's the report of the health department?
Yes.
Let's see what you have done.
Mother,
Urgent direction.
One second.
My
Just because there's a moment of silence is not a reason for everybody to just.
says State Department through, your losses may see page 1, 2, the surveillance, the restroom.
No, page 1 is state government has issued comprehensive guideline on 19th August.
Next page.
Next page, Mother, next page.
Sanction 37.28 crore.
No, and after that, CCTV, Mother. CCTV surveillance cameras in medical colleges, other hospitals. State government has taken and installed additional CCTV cameras in all government.
1,747 CCTV cameras were functioning in medical colleges. Why would this offense have taken place?
Yes, you're right.
But state government has taken the initiative to install additional 6,178 CCTV cameras.
Yeah.
Are being constructed. 893 additional duty restrooms are being constructed. Illumination is, state government is looking at the installation.
That naturally, Mother, these are not, they're not available there, Mother. So we have to do this right away, Mother.
But tell us one thing. What is it that the state government has installed at RG Corp, for instance? Tell us at RG Corp what additional equipment has been installed after we took charge of the matter.
All right, I will tell you that, Mother.
Not just that sanctions have been issued. We want to know
your
what is
lordship is absolutely
what is the progress on the ground that the state government.
Kindly see, we have said at page 4, Mother, that we are taking up works regarding security infrastructure upgradation of RG Medical College as suggested by CISF and assigned an amount of 50, a copy of memo dated so-and-so. State government has given distress helpline numbers. CFS told us we are moving forward, Mother, in that direction.
Tell us by the next day.
Very well.
On what steps have actually been implemented on the ground.
Sure, Mother, we'll do that.
We are back to work, my lords.
Definitely.
And let the district collectors, we look at the government hospitals. Let the district collectors.
7, Mother.
1 second, please. Let the district collectors engage with the heads of each of the government medical colleges and ensure that whatever steps have to be taken are taken in the next 1 week.
Very well, we'll do that. But in the meantime, may I be able? Can I have 5-7 minutes of your lordship's time, Mother? I'm sorry to trouble your lordships. Mullahs, kindly have a look at page 5 of this report, Mullahs. Para 7. So see the problem that we are facing. 23 people have died, Mullahs, because they don't come to work. Para 7, further, the resident doctors of different medical colleges and hospitals across the state have been abstaining from duty for the last 28 days. The healthcare system is facing severe disruptions and can come to a standstill as resident doctors are the backbone of the healthcare in government medical colleges and hospitals. Due to continued ceased work, public at large is suffering. Some of the details are as follows. 6 lakh individuals have been denied treatment as resident doctors are not attending OPDs. Where do we go from here, Mullahs? Causing the delayed number of attendees of government medical colleges to drop from 70,000 to 40,000. This has restricted access to specialty and super specialty treatments, especially to poor patients such as cardiology, oncology, neurology. These facilities are only available in medical colleges. Cardiology treatments such as stenting and angiography have been withheld for approximately 1,500 patients. Then, Mullahs, 20 cases of deaths have occurred. In the meantime, Mullahs, we are now, another 3 have died, Mullahs. They don't go to work.
May I answer that?
1 second.
My lord, may I answer?
Your lordship said last time, I remember now, allow me to please say something. Your lordship said last time that you must go back to work. They don't go back to work, Mullahs.
Can I answer that?
1 second.
None of our doctors are on stress.
Before you answer it, allow him to make his point.
Yes,
Exactly that.
yes.
So, Malad, therefore, your lordships may now indicate in your order that, Malad, if they don't go back to work, Malad, then proceedings will be taken against them. But it can't be, Malad, that people die, they don't go to hospitals, and Malad, if it's a cancer treatment, we are sending them to pilot hospitals, and they are dying there because they can't get this treatment.
Doctors are back, but
May I help you? My lord,
We have, may I help you, booths, Malad, we have set up all over they have ransacked those booths. This is what's happening on the ground. But Malad, because we don't get any time to even address your lordships on issues. And I'm very happy, Malad, at last we've got an opportunity. Then what's happening is, Malad, now protests are taking place all over the state. There is no program that is submitted to the police. There is no route that is submitted to the police. There is no permission sought from the police. They are protesting all over the place. Now, Malad, what do we do? This is what's happening on the ground. And now, Malad, it's turned into something entirely different, which I don't want to mention, Malad.
Who's appearing for the Doctors Association?
my lord, I'm appearing for the doctors.
I am for senior doctors, my lord.
Show your lordships the photographs. 41 police personnel have been injured.
Doctors.
One has lost his eye permanently. And Malad, I've seen the photograph.
Not by doctors.
And they are denying treatment to the police. That's the other thing that's happening. And there's blood over their bodies, Malad. I have the photographs with me. If I show them to you, your lordships
My lord,
will shout.
my lord, I appear for the
Malad, kindly see now.
grant.
Malad, kindly see the page 69. Yes, kindly see page 69.
If you can give us what he is saying.
Page 73 of our status report, of the police report. Malad, kindly just give me.
The state was
Allow
quite
me, Malad.
silent.
One
Lord.
second, please.
State
Mr.
was quite
Solicitor, I
silent
never
when your lordships
interrupted
were
you. Allow me
examining
to
the
say
offence.
something.
Now the state has
Mr.
become aggressive.
Solicitor, allow me to say something, please.
Lord,
Doing this all the time, interrupting whenever we. Malad, kindly come to annexure 44, page 73. Allow me. Please allow me. Malad, this is not fair, Malad.
Highest authorities of the state of West Bengal,
Malad.
they have said that a person had died within
Malad.
continuous and profuse bleeding.
Allah.
But that was a statement made on social media by one of the.
Malad, kindly see 73.
On duty, are they not on
No.
My lords, if I may
allow-
clarify, there are two
Can I-
sets of doctors.
Can I address your lordship
One second.
one
Yes.
by one?
Order. Do we record the assurance of all the council appearing on behalf of the doctors that you are on duty and you're not abstaining from work?
They are on
We are
duty,
not
they are
on
not, and
duty.
they will say why. We are on duty.
1 second.
Can I
Miss
address your
Solicitor,
lordship?
Yes, what is your statement?
So our statement is that the West Bengal Calcutta doctors, junior doctors are not on duty. There are 1737 hospitals and nursing homes in West Bengal, in which 1500 are fully on duty. Senior doctors, even in the balance, 200 odd are also on duty, but the junior doctors are not on duty because
Across the state of West Bengal?
no, Calcutta, only Calcutta. So the figures are for the whole of West Bengal, but the ones who are not are in Calcutta and its periphery. They are not on duty because they are still getting threats. People are being told, we know your father's in government service. We know what you will face.
No
I have
complaint has
given.
been filed, they say anything.
1 minute. I have filed an application. I have given in sealed cover the name of some of the miscreants in KG court, RG court. And I have given a detail of at least 5 or 10 hospitals.
Putra, we will direct that if the doctors resume work immediately, no adverse action shall be taken against them presently because of the fact that we are seized with the matter.
My lord, can I
But equally now, if they do not resume work as doctors, then we can't restrain the state government from taking disciplinary action. That's entirely within their jurisdiction.
My lord, first the action has to be from miscreants who are actually threatening them day in and day out. I have given examples of complaints by Burdwan Hospital, Midnapur Hospital, Medical College, Kolkata, Not, I didn't want to burden your lordship, so I gave 4 examples in Calcutta itself where there are threats to the doctors from within and without, just because. So we had, obviously, my lord, all they are asking, we should have separate rooms, separate toilets. I'll tell your lordship.
What are the threats about?
The threats are they are just bullying, beating. 1 minute, because several of these persons supported the RG Kaur protests. So many of them are being victimized. There's a group which is being headed by a medical forum. I don't want to name it. I don't want to make it any political. I'm only saying apolitically that it cannot be that just because these students, and they are doing volunteer duty just outside the hospital in camps. They are working in various health clinics, and I can show the photographs.
Might as well go back to your work.
No,
in the
because
hospital.
there we are receiving. So what I'm saying, we need a room for females to rest at night because 36-hour duty. We need a room for males separately. We need toilets for them. We need CCTVs. We need senior women, CISF people near us so that we are not threatened. I have no difficulty. If I can work inside, I can work inside, but I have to have a safe environment. And I have given a sealed cover. Sorry.
Ms. Luthra, just give us 30 seconds.
Sorry, my lord. Just.
If you have the information on hand,
Yes.
you may give it to us. At a time, doctors, they work for 24 hours.
Yes.
Right?
Yes.
At a time in a given shift, how many resident doctors work?
Okay, I'll find out, Mullas. I'll find out. I don't know, Mullas. I don't know. Mullas, may I request, apropos her complaint,
Female doctors are there at a time.
I'll find out. I don't know, Mullas.
Totally, how many hospitals in public hospitals in the state of West Bengal? Is it correct? 1737?
Basically, Mullas, all the really healthcare network is in Calcutta itself. The large part of the network is in Calcutta.
How many government hospitals are there?
In Calcutta or all over the place? In West Bengal. Government hospitals in West Bengal. We'll just find out, Mullas.
And in Calcutta?
We'll find that you should be able to.
All right, ऐसा लिख लीजिए.
About 24 or so.
Just 1 second. During the course of the hearing, a grievance has been made by the government of West Bengal in regard to the mass abstention from work of doctors from government
Junior
medical
doctors.
colleges.
My lord, it's it's only junior doctors.
Words in his mouth, right? Of the of the abstention from work of resident doctors of medical colleges and hospitals across the state for 28 days, as a consequence of which the healthcare system is facing severe disruptions. Full stop. Paragraph 7 of the status report, paragraph 7 and 8 of the status report, which has been filed by the Health Department of the state of West Bengal, are set out below. Copy down that. Next. We are of the view that before that, you say the state of West Bengal must take necessary steps to create a degree of confidence, to create confidence in the minds of the
All doctors.
Of the doctors, that their concerns in regard to security and safety are being duly attended to. Full stop. In order to ensure this, all the respective district collectors and superintendents of police shall take stock of the situation and ensure that necessary conditions have been created for ensuring the safety and security of all doctors in the government medical colleges and public hospitals, including, to brackets, provision of separate duty rooms for male and female personnel, semicolon, bracket 2, availability of toilet facilities for male and female personnel, semicolon, and bracket 3, the installation of CCTV cameras. Full stop. In the affidavit which has been in the status report, which has been filed on behalf of the state police, it has been indicated that funds have been sanctioned by the state of West Bengal for setting up additional CCTV cameras in the government medical colleges and hospitals, and for carrying out necessary structural work and for carrying out necessary work towards creating other attendant facilities for the doctors. Full stop. This shall be continuously monitored by the district collectors in conjunction with the superintendents of police. Full stop. In order to create a sense of confidence among the doctors, we also direct that in the event that the doctors report for duty within a period of on or before 5 p.m. tomorrow, no adverse action, no adverse disciplinary action shall be adopted by the state of West Bengal. Full stop. Moreover, in the event that any complaint is made for their abstention from work for the antecedent period, full stop. In the event that any further complaint is received in regard to the lack of safety or, as the case may be, security, such complaints shall be promptly attended to by the superintendents of police by making suitable arrangements with the local police stations concerned. However, if there is a continued abstention from work despite the above facilities which have been directed to be put into place, there may be a likelihood of adverse action being adopted in the future, which may best be obviated by the return to work. Full stop. The resident doctors must be aware of, cannot be oblivious to the needs of the general community whom they are intended to serve, and should reciprocate by returning back to work within this period.
May I just... One second, hold on, I have not yet finished. Allow me...
This is one aspect. One, we are only 2% of the doctor force. We are just junior doctors. So the senior doctors.
But you can't say others are working, so we need not work.
No, I'm not.
You have to get back to work.
I'm unsafe. I'm only saying, give me 3 days and let them put an affidavit of compliance in place.
Yeah, we are giving you 2 days. We have asked them within these 2 days for them to take necessary steps. That's why we didn't say today. We have given until 5 p.m. tomorrow. Right?
May I now? What is all this?
Yeah, but one of the most associated that a boy died out of...
Anyway, look. We are not here to either lend a ear to the politicization of the matter or other. All that we want to, we want to ensure that due security and safety is provided to the doctors, but equally, the young doctors must now return to work and attend to their patients.
Well, one second, I haven't finished. Just allow me, please. I'm on my... Well, let's see what the protection is. Well, let's see page 73.
We know what is happening on the ground. All that we want to assure the doctors is first return to work. We have said that the district collectors and the superintendents of police will monitor the situation. They shall provide adequate facilities to ensure their safety and security. They must now come back to work. You can't say that, well, others are on work, therefore we will not work.
That's not at all an argument.
But
I'm just saying that.
Equally, we have put everybody on notice that if they do not return to work, then please don't hold anybody responsible if disciplinary action is taken, because then we can't prevent any government.
We are more than willing to work if we are working outside.
Hold on. May I finish?
May I say one thing?
What? I haven't finished, my dear.
There is a threat.
Take your turn after lunch.
Ms. Luthra, we have therefore taken care of your submission on the threat. We have said that.
My lord, the names of the miscreants, can I give it to this
Give it to Mr. Solicitor.
Yes, my lord.
Yes.
There are several miscreants in this hospital itself. We are giving.
Malad, may I finish, Malad? Now kindly turn to page 73, Malad, of the police status report.
So what is that?
Well, just have a look at it, Malad. There are some photographs your lordships will see, Malad.
Yes.
Give it to my lord.
One second. You filed it, right?
Yes, we filed it. Therefore, I'm saying yesterday we filed it, we circulated. We have a hard copy now, Malad.
Status report by Kolkata Police.
Page 73, Malad. Annexure 44.
It may be
44.
Otherwise, I'm not.
It only goes on to Annexure A37.
No.
Page 73.
Page 44, page 73. We've got hard copies. Just have a look at it, Malad.
Very small.
PDF
78.
PDF should be 78, I believe, Malad.
Anything else left? That he's dealing with. Against threat culture.
On the ground, Malad.
Therefore, we've asked the doctors to come back to work first and foremost. And we've seen this as well.
Yes. Okay. Now, Malad, two more things. Number one, Malad, there should be no protest without an application to hold the protest, and the route to, they just hold the protest without informing anybody.
In our last order, we have clarified that when we said that you will not take any action against peaceful protesters, we had equally said that.
One second. Once.
Respect of any protest which.
Well, see what is happening.
And protest will not be, any protest will not be at the cost of their duties.
Yes. This is not clarified. This was not clarified, Malad. This is not the doctors. These are not the doctors, Malad.
All right, let him say what he has to say. We got your point.
Nobody has protested beyond duty time.
As letter was sent to the protesters by the Kolkata police, wherein they had sought for certain information. But in that letter, it was categorically all the necessary information was served upon the police with regard to rally that they mark that is going to be.
No.
Everywhere. False statements have been made by them.
Malad, which court are we in, Malad?
Unleash their courts. No regulator.
Well, this.
Kolkata police, nor the West Bengal police, they did nothing on the part of the regulatory.
All right.
And it's beyond duty.
One last word, and then we are going to rise for lunch. We want to ensure that the doctors resume work.
Only one thing, Malad.
Doctors are in the system to render service to the patients. We will provide every kind of measure of security to the doctors, but they have to reciprocate. We have said that no adverse action shall be taken.
Yes, please.
My lords, if they are also protesting and joining work.
We have CCTV footage.
When we said that no, 1 second, we said that, why don't you hear what we said? We said that no adverse action shall be taken against the doctors. Mr. Sibal, please ensure that those of the doctors who resume work, please don't take any action.
It's our duty. It's our duty, It's our duty. This gentleman who is before your lordships, I have got videos, photographs, he's throwing stones.
Lordship, there has been
this gentleman.
A threat culture has been established.
Mr. Sibal, Learned Senior Counsel states that no action, including punitive transfers, shall be adopted against the doctors who return to work in terms of the directions and stipulations.
Those are the peaceful protesters also, right?
And IA.
Kindly see.
Because the individual who was found to throw stones.
Yeah.
These sort of submissions come from.
One second. Are you trying to address the gallery outside the court?
That's what he's doing.
1 second. Can we just, I've been noticing your demeanor for the last 2 hours. Can you first lower your pitch?
I'm sorry.
Please lower. 1 second. Listen to the Chief Justice. Don't raise your voice. Lower your pitch.
My lord,
Second, you are addressing 3 judges in front of you, not the large audience which is watching this proceedings on the video conferencing platform. 2, Mr. Sibal's statement, we can't start recording every police officer's statement here, right? Mr. Sibal is representing the state of West Bengal. We have recorded that there will be no adverse action, including punitive transfer. You said transfers. We have said, therefore, no punitive transfer shall be resorted to. Right? Therefore, there's no point in raising
the peaceful protesters. The last thing is the application we have filed. Well, there's an application for direction that I have filed, which has some really serious things that your lordships have to deal with. Well, the kind of things that are in this application and the statements made in this application will destroy the credibility of institutions in this country if this is allowed to happen. Well, I seriously, I request your lordship.
Sibal,
Yes.
have a copy given of that to Mr. Sultan.
Yes, I will do that.
please give it to me.
I will do that.
Only
Well,
one
and,
thing.
and Manoj,
Lordships, may I?
your lordships must be on this, decide on the parameters
May
that are to be adopted in matters of this nature. Because this can't go on, Manoj. It will destroy institutions. I can tell your lordships that. If this is allowed to go on. And your lordship, Manoj, lawyers are threatened.
Lordships, may I mention?
Our lady lawyers are threatened, Manoj. This is what is happening.
Your Lordships, may I mention an IA? Your Lordship,
Kind of things that have been said, Manoj, your lordships can't imagine.
My lords, can doctors and other peaceful protesters be protected? Other government employees, my lords.
We have said doctors. We are concerned with doctors here.
Yes,
We
my
are
lords.
concerned with doctors. The others, we are in charge of the matter relating to the doctors because this all of it originated in the act of the crime at the Ajikor College. We are not concerned with the wider aspects of what government employees are doing. That's for the state government to handle their employees. So far as the doctors are concerned, because we are also concerned about their safety, we have said that their safety shall be protected, but they must go back to work. We are very clear on that.
My lords, I seek
If all of you,
Your Lordship,
7 or 8 people, at least in the last 20, I'm not used to this kind of advocacy where 7 or 8 people are arguing at the same time.
Application.
We'll now take up the matter, I think.
my lords, your Lordships, may I mention an IA? Your Lordship.
This must stop.
My lords,
This
if
must stop.
I seek a very single direction.
Stop.
My lords,
Lord, only one line.
my lords,
Instead of assisting the court,
Sir.
the state has sought to politicize, but Lord, I can't help it.
my lords, one line, if I may.
Politicized.
It's a very limited direction with respect to the constitution of the NTF, my lords, if I may, please.
If this is called politicization, God save this country.
Yes, my lords.
What do you want to say about the constitution of the NTF?
My lords,
Surely you know this, that when an order is passed by the highest court,
yes, my
you
lords.
can't just bring up and say, I want a change in the constitution.
Not a change, my lords. Not a change, my lords. Only one consideration by my lords.
Yes.
My lords, all I pray is that one representative of the dental association may be added to it. And there's a reason for it, my lords.
We have asked the NTF to engage all stakeholders. Are you a stakeholder? Are you not a stakeholder?
We are stakeholders, but there's a reason.
Therefore, all that you have to do is you submit an email. Last time we have created a portal where any request can be made to the NTF. Submit an email on behalf of the Dental Association.
Sir.
We have these concerns. Please take these concerns into mind. They will hear the Dental Association.
Yeah, my lords.
your Lordships, if I,
Adding people in there. All that you have to do is you have to submit. We have laid down modalities
Sir.
for every stakeholder to engage with the National Task Force. We can't have individuals now inducted into the task.
your Lordships, if I may mention,
My lords,
your Lordships,
there is
if
a
I,
reason that I'm.
your Lordships, if I may mention, your Lordship,
Participating in the protest, day-to-day protest, who participate in the reclaiming of nights, and who are also holding their protest peacefully throughout Calcutta or other suburbs area also. Kindly, police should not take any adverse steps against.
What we have said last time still continues to remain in operation. That's not until today. That's an
They
order.
don't ask for permission, Malad. They don't ask for, it's not peaceful. You've seen the photographs.
Yeah.
All right, that's all right.
Your Lordships,
We are keeping it next week now. So.
Your Lordships, Your Lordships, I have a small submission.
All right, this young lawyer here, yes.
Your Lordships, I appear for senior doctors in the state of Haryana. Your Lordships, the state of Haryana had an act in 2009. It has been 19 years, Your Lordship, there's been no implementation. The first FIR that was even registered was in 2017. Your Lordship, what...
We'll have to delink your matter and deal with it as an individual matter separately.
Your Lordship, what I propose...
Instead of the intervention, you file whatever you want to file for implementation.
I propose, Your Lordship, I have a proposal. If Your Lordships may direct the state governments to send a status report to the NTF, so the NTF can take into consideration the ground realities and why have the acts not been implemented till now?
But that's one act.
No, Your Lordships, there are 21 states which have the act.
No, we have referred to that in our.
Yes, Your Lordships.
But can we issue those directions in an intervention? You must also know that there's.
I'll file.
While your lordships are rising, all this should not happen, Manoj. I'm sorry to say, but this should not happen at all.
Can you just pass it?
My lord, before your lordship takes up item 2, my lord, may I respectfully submit?
Not in the previous matter.
No. Only thing, my lord, only previous matter. I'm not saying on marriage.
No.
We have
The previous matter is over. Sorry.
We have a grievance, my lord, that we are not heard because we are disciplined members of the bar. Those who shout, my lord, they are being heard.
That's all. For your compliment. Item 2.
Very well, lord.
Your Honor, I have come from Pune. I'm Dr. Rajiv Joshi. I have come from Pune.
Item 2, I am appearing.
Item 2. Yes.
I want to give some documents.
It is being called out, sir.
The only submission, Millard, is this whether it is a single project or not, Millard.
Yeah.
Kindly
They are different projects, different RERA.
Millard, kindly appreciate, Millard. That's my submission. The only submission, whether it is a single solitary project, and 2 documents. One is the sanction plan, another the builder or the project promoter's document. Kindly appreciate, Millard, the 2 documents, and that's it. I won't bother you beyond that. Kindly come, Millard, to page 751, 752. Otherwise, it is in volume 3, Millard. And this is nothing but sanction plan, Millard, of the entire township. Township have many facets. There may be sub-projects.
Substantial question of law on this.
No, Millard, if your lordship won't mind, as I said, I'm not going to pursue it further than these 2 documents.
Yes, 751.
And I'm sure I will persuade.
Annexure.
Annexure 14, Millard, page 751.
Yes.
And kindly see, Millard, at the bottom of the page, Millard, of rather the sanction plan, project name. On the left-hand side, your lordship will see that.
Once there are different projects, project finance is arranged differently.
No, Millard, kindly, the sanction plan says it is one project, high-tech city, Dadri, Millard, and then the land uses are different.
Which is the second document?
The land uses, your lordship had seen in this, are separate. The commercial, the group housing, etc., etc. The second document, Millard, is their own letter on page 357. It is in volume 2, Millard, of the builder itself, Ansal High Tech.
Annexure?
Annexure A2, Millard. A2.
Yes.
Page 357, Millard, and dated 22nd July 2011. Now, kindly see, Millard, in this very document, one document in 4 places, they are saying this is one township. Kindly oblige me by referring to the first sentence itself. You must be aware that your prestigious Susant Megapolis, the high-tech township project. Township project they are talking in Millard. And in the third, the middle para again, in 3 places they are talking your project. So the project is only one. Kindly appreciate, Millard. And RERA for different reason. Your lordship is much more.
After concurrent findings, there are no substantial questions.
No, may not be, Millard, but kindly see the home buyers, where they will go. There are more than 1,600.
The IBC. You have other remedies you can pursue.
And in IBC, Millard, we went to NCDRC, a group of that. Now execution is a problem there, Millard. And now when IBC had come in picture, Millard, there is further frustration for the home buyer. And your lordship had always protected the home buyers, Millard. That's my experience, and I thought I will be able to persuade you.
Thank you, Mr. Lavati. Thank you.
In some kind of mediation or something.
Yes, thank you. Item 3.
Grateful, man.
It is identified contradiction.
Item 2. Item 3. Item 3.
Yes, sir.
What is this kind of a petition? If your client, who is a professor of logic and philosophy, claims to have found contradictions
Yes, sir.
in the curriculum prescribed in the framework and curriculation of natural science, and you say that conjectures of global science are being taught compulsorily as natural science. I mean, how can we get into this pure issue of academic policy?
Yes, sir. That is academic, and he has tried for many years.
These are matters of academic policy. We can't enter it.
It has been sent to various academic associations. They have all returned it. So that's why at the last resort it has come to your.
According to you, latitude and longitude are imaginary lines. Likewise, the division of the earth into the northern and the southern hemisphere are imaginary concepts. And these are not, according to you, part of natural science, which should reflect fundamental truths. That's the case. I think we leave it. Nothing. The petition raises a pure issue of academic policy and hence is not amenable to the jurisdiction under Article 32 of the Constitution. Petitioner. Item 4. Jharkhand High Court has not established an online portal.
No, I have checked it also. Yes.
Why don't you file a writ petition instead of filing a contempt petition? File a petition in the High Court for that there's a direction by this court. Go before the High Court, right?
There has been a direction, and the purpose has been because I am the one who has been suffering, and I'm trying on the one plea.
High Court to pursue a remedy. We have already laid down the law.
Approach.
The petitioner would be at liberty to move the Jharkhand High Court for appropriate proceedings, bearing in mind the grievance that the High Court has not set up an online RTI portal. It's leaving it open to submission. So the contempt petition, the petition is disposed of. Very cool.
Wait, please, Your Lordship.
Yes.
Your Lordship, in this case, the petitioner got a provisional allotment letter, Your Lordship.
And then it was cancelled.
Then it was cancelled on the ground that she is suffering from a disability which is more than 80%.
Right.
Subsequent, Your Lordship, earlier, the institute examined the petition wherein the disability was less than 79%, less than 80%. Subsequently, when she got a provisional allotment letter, the state medical board examined and found that the disability is 90%. And therefore, the candidature was cancelled.
What does the notification provide?
Yes, I'll just take Your Lordship to the notification. That is all. Page 20, may kindly see. Yeah. Your Lordship has page 20.
Yes.
Your Lordship may kindly see the first part and the disability range in that the middle column, eligibility for medical course, eligible for PWD quota. 40 to 80% disablement. Person with more than 80% disability may also be allowed on case-to-case basis, and their functional capacity will be determined with the aid of assistive device. If it is being used to see if it is brought below 80% and whether they possess sufficient motor ability as required to pursue and complete the course satisfactorily. Now, my respectful submission is, Your Lordship, the medical board ought to examine two things, Your Lordship. The first is what is the percentage of disability, and secondly, the medical board ought to have considered the fact whether with the said disability, even though it is
with assistive devices,
with assistive devices, even if the disability is more than 80%, whether she'll be able to completely pursue the course of MBBS or not. That is the second thing that they have not examined. If I'll take Your Lordship to the certificate.
Yes. At all.
No, Your Lordship, may kindly see the certificate.
We'll do this. Issue notice on the application for condonation and on the special leave petition.
Please, Your Lordship.
Returnable on. Keep it after 2 weeks. Thus the permitted mediation. Who are the respondents?
Your Lordship, the respondent in this case is
State of Chhattisgarh. Liberty to serve the standing counsel for the state of Chhattisgarh in addition.
And also, Your Lordship, the college in which I got the provisional admission, they are also party. I'll serve Dasti. I'm deeply obliged, Your Lordship.
We'll have a re-examination back games or something.
Your Lordship.
Connect. May I am a sufferer and
I have issued notice in that section 15 challenge. Kopkar's case.
That is coming for 27 September.
Yes, we'll issue notice and tag.
Can I make one request? In the Kopkar case, there was SLP also, and in tag matters, there are SLPs also. Now, my SLP has been listed by the registry before code number 7. So that, because
Sorry, you tell court number 7.
I have told Your Lordship, just say we will examine whether it is connected, because my substantial issue is this. Even the report has been given by the registry that the matter is pending before this court. So I can't, I have...
All right, we'll see what to do. Next, just remind us on the next on the 27th when it comes.
Please, please, Your Lordship.
Main exams have also been held here.
Yes.
What can be done now?
Lordship, this is...
You are now dealing with the preliminary exam.
No, that's the second time that's happening. Last year also the same thing.
I know, but now with the main exams having been held, how can we now go into the preliminary exam? You are relying on 3 questions, questions 9, 48.
Not religious questions, Lordship. My objections are at the 4 level. And most important is also is the cutoff. Lordship may have page number 7, Lordship, of my SLP.
There was no cutoff for the screening test, for the reason that the screening test was only to ensure that the number of candidates who appear for the mains was 10 times the number of vacancies. Therefore, otherwise there was really no cutoff as such. It only...
If you see, Lordship, the page number 7, the judgment, the part of an order that has come from the Honorable Court, the page number 7, Lordship.
And there were not enough categories, not enough students from SC, ST categories. Therefore, they said with candidates with lower marks were also deemed eligible for the main exam. Otherwise, whether they appear or not, they have to clear the main exam.
But in unreserved categories also, as per the High Court, the cutoff is 233. They have also allowed students who have scored 230, 231, 232 to also appear. So the cutoff which they have given, I mean, what is the sanctity of cutoff which is being given? And then there are people who are appearing who are below.
You were below it also.
No, but these are in unreserved. So there are issues in unreserved categories also, the female categories also. So the cutoff, what they are saying is 233, the next cutoff. But also they are allowing somebody who has scored 232, 231 and all to appear in the examinations.
But thereafter they may have failed the main examination. They may have failed the main examination.
But my score is, Lordship, 210. In that case, somebody who is getting 212 in the unreserved female category and the cutoff is 213. Now the High Court is saying the cutoff is 213, but they are allowing somebody who is to appear in 212.
Can't interfere at this stage because your whole grievance is about the preliminary exam. That after the main is taken place, therefore the preliminary exam now ceases to have any relevance.
Lordship, there has been instances within the High Court itself where 2 times the examination have been conducted in the past. 2021 also the same thing.
Prepare better for the next exam because now everything has come to an end with the main.
It has not come to an end, Lordship, because the results have not been announced also.
Now we can't have a fresh preliminary exam for you now.
No, I'm not saying the
or a fresh main exam. The main exam is also held.
Lordship, the issue has, I mean, the whole judgment.
I think we'll not interfere.
Judgment says that 233 and they are allowing somebody's.
Item 8. 8 is a section 11 matter, right? We'll issue notice.
For the applicant.
We'll issue notice, make it returnable in 3 weeks. Thus the permit. Liberty to serve the respondent by email in addition.
Lordships, I had just one request. I have seen the records. The respondent is quite responsive. He is responding to emails, etc. Returnable date may be given. Ultimately, the
make it returnable, yes.
I am deeply obliged.
Item 9.
So, my lords, there are already a bunch of petitions which
so why should we transfer your petition? You go on with your petition before that.
I'll just explain why. My lords, ours is a notification.
Your petition of 2021.
So what has happened is this: we have it's in respect of a notification of 2018, right, under which, my lords, this temple has been acquired under the 23B of the Act. Now, my lords, I cannot challenge 23B before the High Court because the High Court actually decided the constitutional. It struck down the validity of the Act, and the matter is pending over here. That bunch. So, my lord, it would significantly enhance, my lord, my case if I am able to address the court on 23 as well, which I cannot do before the High Court.
But you can intervene in this proceeding because your petition is independently also challenging the takeover, not just the.
Yes, but below that can be relegated. But what would happen
Otherwise, what will happen is that if we tag it here, our court will be dealing with those issues on merits also.
My lord, all the court would.
Unless you're giving up everything else.
My lord, if the validity is decided in my as in the act is struck down, then in any case,
but if it is upheld, then you'll still have a challenge, right?
I still have then it may be relegated. But my lord, at least
that's it. Why this? You can intervene in the pending proceedings on the constitutional validity. So you have your day in court, you file an IA for intervention.
Liberty to do that.
You can do that.
Well, your lordship may indicate because once a transfer petition is.
All right. Since the petition under Article 226 of the Constitution is pending before the High Court of Karnataka, there is no reason or justification for a transfer of those proceedings here. However, we clarify that in the pending proceedings before this court, where the validity of Section 23, capital B, right?
No, my lords, just B.
23?
Just B, small b.
Bracket small b is stated to be in question, it will be open to the petitioner to move an appropriate application for intervention if they are so advised.
Very well. And my lord, we hope that the High Court will also expedite it, a 2019 petition. Yes. Very well. I'm obliged.
इसमें गवाही साहब ने नोटिस इशू किया है.
If you may please, my lords. My lords, an identical set of matter, my lords raising question of law, same question of law. Notice has been issued, my lords, as the office report indicates, my
Writ petition 311 of 20.
my lords. And subsequent to that, there are two other petitions as well. However, my lords, that batch of matter is listed before court presided by Justice Gavai in courtroom number 3.
Issue notice and tag notice.
My lords, stay as well because, my lords, may kindly see page 32.
Not grant a stay right now.
My lords, the stay will be required because if the arbitration proceedings, my entire foundation of challenge is that it's a central government.
Ultimately, if you succeed in the arbitration, nothing remains. You won't stay it, but on the question. In fact, we have ourselves reserved judgment.
My lords, I'm full aware of
So that we cover this, our judgment will cover this issue as well.
Very well, my lords. Grateful. My lords, item 33 as well.
33 as well.
Read.
Item 11. Actually, Mr. Agarwal, in this,
Yes, my lords.
when the renewal was made on 15th March 2017,
My lords.
the lease rent was increased to rupees 16 per square foot.
Right, my lords.
But for 16 to 19.
Yes, my lords.
But clause 3 said
Yes, my lords.
that the proposal for rupees 26 per square foot is pending consideration by R3.
Right, my lords.
And a revised agreement shall be executed thereafter.
Right, my lords.
Now, government has notified the enhancement in rent to rupees 25 per square foot,
Correct, my lords.
but prospectively.
Right, my lords.
You are claiming retrospectively.
Because we negotiate.
Petition.
Because we negotiated, the commissioner of commercial tax has negotiated with me, reduced the rent. Please see his letter. One letter, not.
No, but it's a commercial bargain.
That's why. That's exactly. That's what is
You can throw them out if you feel that if the rent is inadequate.
No, the plus just have 2 pages at page 73.
Even your agreement for renewal with the government says
Yes.
that you are negotiating with them. Once a government order is passed, that will apply to your bargain.
Absolutely.
Now they revised it, but prospectively.
So, just give me 1 minute.
How can the High Court under 226 direct that you must give it from a particular date or a particular date?
Can I indicate? Because this is a 5-floor building. The commissioner of commercial or commissioner taxes and I enter into an agreement, and please see what the commissioner writes to the government. It's not my IFC.
Saying what?
So commissioner says this, please have 7.
He recommends to the government.
Saying that the commissioner says, I have settled it at 25 rupees. Market rent is 55 rupees. Therefore, I request the government saying, please accept 25 rupees from 1st April 2016. See, the commissioner of commercial taxes writing to the government is not me. He has sat and negotiated. Please have 74 minutes. Just have page 74.
Ultimately, feel you'll get much more in the open market.
Right.
You evict them.
So I wanted to. Then the commissioner said, let's sit and negotiate because they have been occupying from 2003, 5-floor building in Hyderabad, 50,000 square feet. Then the commissioner of commercial tax, who is the head of the department, writes to the government. Just have a look at page 74 minutes. Just 4 lines, Milos.
Not under 226. Imagine the High Court saying, you must revise the rent with effect from a particular period in the past to at this particular rate.
My challenge was this: when the government is revising the rent from 1st March 2018, it has not indicated why from 1st March 2018, because the commissioner had made a recommendation.
It's a commercial bargain.
That's exactly what I'm relying upon, that the commissioner with Milos, I have a discussion with one officer.
Public law.
I understand, Milos, but I have a discussion with the head of the department. He writes to the government saying, this is what is agreed to.
Conceptually, we can't grant this relief. Conceptually, this can't be granted.
I only challenge that part which made it prospective, Milos. That's all there is to it, Milos. Yes. Can I just read one page and leave it?
We've seen that page already. Thank you.
Grateful.
Sorry, we can't have it. Obliged, Your Lordship.
This is an important petition dealing with international humanitarian law. In fact, Lord, Gaza is
What is the
facing
relief?
worst. The relief is to
You are seeking a direction to the Union of India to cancel existing licenses and all the issuance of new licenses for the export of arms and military equipment to Israel.
That's right.
Mr. Bhushan, how can the court adopt this kind of jurisdiction? It's a matter for the conduct of foreign policy or defense policy.
No policy can be against.
We can't tell the government that you shall not export to, say, country X, or that you will cancel all license for defense exports to a particular country. It's a matter of it's a matter of national policy.
If the export is to a country which is committing genocide, the International Court of Justice has held so, the Hague Court of Appeals has held so, the UN experts say so.
But way municipal courts and the government of the day, ultimately the conduct of two aspects, the conduct of war. Of course, we are not dealing with the conduct of war by the Union government.
Correct.
But the conduct of foreign policy is entirely a matter for, it's a political expediency of the government of the day.
With great respect, my lord.
We can't say to the government that you are exporting, say, solar power, or you are exporting, say, you're supplying oil to a particular nation. Stop supplying oil. I mean, where do we get that jurisdiction?
Yes, my lord. So let me answer that. If the export of arms to a country which is committing genocide, which has been held by the International Court of Justice to be committing genocide, and those arms are going to assist, aid and abet and assist in that genocide, then, my lord...
ICJ didn't go as far as to say that Israel was committing an act of genocide.
Yes.
ICJ's judgment was a very guarded judgment. They never went to that.
No, in fact, my lord, they have said, if
ultimately, Mr. Bhushan, the point
is
is this.
Provisional measure.
Any such direction will immediately impact upon India's conduct of foreign relations with a foreign state.
But this is a very
To what extent should the government do that, not do that? It's a matter of national self-interest as evaluated by the government. How do we prevent the government from doing that?
With great respect, my lord, if that national self-interest is against the law, is against the law, against the Genocide Convention.
But look, see, under the Foreign Trade Regulation and Development Act or the Customs Act, government can ban. For instance, in the case of Pakistan, I remember, we dealt with the Brother Justice Joseph and my judgment. What time did the notification come into force? A very interesting point which we decided. But it was, if the government issues a notification under the Foreign Trade Act, banning, then that has to be enforced.
No, I agree.
But can the court direct the government?
One more aspect would interesting. I would like to be heard.
I'll answer your
aspect would
question.
be: will the Constitutional Court of one country
only make my submissions, my lord? If the Union of India wants to respond to it, they can respond to it. But my lord, if they don't want to respond, then they should file a form.
Now see Article 253.
Yes.
Notwithstanding anything in the foregoing provisions of this chapter. Page 250.
What is your lordship reading?
Article 253. Parliament has the power to make any law for the whole or any part of the territory of India for implementing any treaty, agreement or convention with any other country or countries or any decision made by any international conference, association or other body. Absolute power of Parliament to either implement a foreign convention.
They have ratified the Genocide Convention.
But now to convert it into a law is the domain of Parliament.
No, I'm saying...
You can't say that, look,
lordship has
this is what we held. Even if Parliament is silent for some reason, that we direct now that you will stop exports to this country.
There are any number of judgments of this court which say, including your lordship's recent judgment in Puttaswamy, including Gramophone Company, including Vishaka, which say that so long as an international convention ratified by India is not inconsistent with our municipal law, it can be and should be read into municipal law.
Absolutely.
That was the basis.
Absolutely correct.
Now, my lord, the Genocide Convention is ratified by India. Therefore, it can be read into municipal law. International Court of Justice is saying that export of arms by any country to Israel at this point of time, when genocide is being committed by Israel in Gaza, would amount to violation of the Convention of Genocide. And therefore,
in our law, the union government is entrusted with the power to ban exports. Right?
Yes, yes.
Now, the union government has not exercised the power for whatever reason. It's a matter entirely of.
But policy cannot be against law. The question is whether an international convention ratified by India can be read into our law, can be understood to be part of municipal law or not. And therefore, any policy, whether it is.
We accept that for a moment. Let's say the Genocide Convention, our law should be so interpreted so as to give effect to an international agreement.
Yes.
You say that we are a party to the Genocide Convention.
Right.
But that's one thing, no difficulty at all about it. But can we say that in the exercise of your duty under the Genocide Convention, you, Government of India, shall ban exports to Israel?
In fact, my lord, in fact,
gravely doubtful because, this is seriously impact. Why is this restrained? Because what is the fallout on international relations? What is the fallout on the position of our India, of the nation in relation to the conduct of international relations?
So your lordship may
something we are not aware of. We don't know what the fallout will be.
Your lordship may read ICJ's opinion on Nicaragua versus Germany. Just read this part. ICJ's judgment on Nicaragua versus.
There's no difficulty. I mean, the ICJ operates in a different sphere. The municipal courts, we are the municipal court, the highest municipal court.
The basis that they have given is, that this will amount to a violation of the Convention of Genocide. And therefore, arms exports at a time when genocide is being committed by Israel on Gaza, to Israel at such point of time, arms which could be used for that genocide.
Now take a different case.
Yes, yes.
There is a war between Russia and Ukraine.
Yes.
All right?
Yes.
Russia today is supplying oil to India.
Yes.
Matter of economic self-interest, our energy needs have to be catered to.
Certainly.
Right? Can the Supreme Court direct the government of India that you shall not source oil from Russia because Russia, theoretically, some petition comes before us and says that Russia is in violation of this particular international convention. We are not saying they are, only for the sake of argument. Can we then direct the government of India that you shall stop importing oil from Russia?
In this
we can't, obviously, because ultimately it's a question of, the energy needs of the nation. It's a matter of the conduct of foreign policy. To the extent to which the government should deal with, say, Russia, not deal with Russia, it's a matter exclusively of the conduct of foreign policy.
Great respect.
Same thing in its application to, say Bangladesh now. There are disturbances which are taking place in Bangladesh. What should be the extent of the economic engagement with a neighboring country? Entirely a matter for government to decide.
No problem, my lord. I am not saying that the court can interfere with policy or foreign policy normally. But this is a very special case, very different case.
Or we had a problem, say, in Maldives, right? We had a defense agreement with Maldives.
Lord, I am not saying, I am distinguishing.
You can't then make a distinction. Look at the consequence. Look at the cumulative consequences. Maldives, we had our defense personnel situated. New government came into Maldives after elections. They said, remove your defense personnel. Can we then say, now people are, say, traveling from here to Maldives for tourism. We have Indian hotels in tourism. Can we issue a direction to the government that you ask all the investment to be repatriated to India?
My lord, with great respect, my lord, that's an entirely different situation. Here is a situation where it is absolutely crystal clear. Any number of UN bodies have said that Israel is committing genocide. Hospitals are being bombed. Schools are being bombed. Aid workers are being bombed. Aid workers are being prevented to supply aid to the dying and starving children and the injured people there. This is the finding of any number of United Nations bodies, which has been noted by the ICJ in its provisional order, by which they say that Israel must take all steps immediately to stop this genocide. And in another order, Nicaragua versus Germany, the International Court says that subsequent judgment, it says that the export of arms I am not at all saying, I should not be heard as saying that this court can interfere with any normal foreign policy. And I agree that this is a matter of normal foreign policy also. But here is a very special situation, very unusual situation. This is a situation, International Court of Appeals, the Court of Appeals at The Hague, Netherlands. Spain stopped a ship which was carrying arms from India to Israel on the ground. From India to Israel, it was en route stopping at Spain. They said we cannot allow this ship to berth in India because it's...
Mr. Bhushan, yes. And we say the situation.
Yes, no.
Before the start of this war between Israel and Gaza,
yes.
If the country has entered into a contract with us for supply of arms or anything,
yes.
And that we have to fulfill that contract.
No, Lord, with great
would you say that it is your assumption that they may be used, your allegations are of genocide?
It's clear, it's clear, my lord, from the nature of the export.
You have raised a very delicate issue, and court should not interfere.
My lord, with great respect, my lord, what is the duty of a court which is to enforce fundamental rights, enforce the constitution, enforce the laws? The duty of a court is to ensure that Article 21 rights, now your lordship has held that the fundamental rights interpretation can be tailored in accordance with international conventions that we have ratified. Article 21 is applicable to non-citizens also. It has been held by this court in any number of cases. Now the question is, when there is a country which is committing, which is no doubt about it, any number of...
That's a very wide statement, no doubt about it.
No, my lord,
wide statement.
Any number of UN, ICJ, human rights, UN...
Very wide statement, we should not.
Lord, it has been said so by the ICJ. Just let me read, Lord, what the ICJ says about this genocide.
Different jurisdictions.
Their role is different.
What, Lord?
Yes.
Sorry.
ICJ says all the UN organizations say that genocide is being committed, hospitals are being bombed, schools are being bombed, aid workers are being bombed, they are being stopped from going and providing aid even to these injured children, etc.
Let's not get into all this. It may unnecessarily create problems for our country. Sorry.
With great respect, my lord, it is the duty of a constitutional court to interpret the law of this country in accordance with international humanitarian law which India has ratified. That's what this court has held in so many cases.
But therefore, does that mean that we issue a mandamus that you shall issue a notification prohibiting exports?
Great.
Otherwise, look at it this way. As Brother Padiwala just said, there will be contracts by Indian companies. Yeah. We are now also an exporter of capital. We are not just importers. Suppose we issue a mandamus as you are seeking, or we grant an injunction.
Yeah.
An Indian company tomorrow is saddled with a claim for damages for breach of contract. They
will say,
I'm ready to supply. I've made arrangements. I've invested money. But because our Supreme Court has now injuncted me, I'm open to a claim for damages in an international arbitration proceeding.
Great respect.
How can we look at the grave hardship?
Great respect, my lord.
These are facets which government can evaluate. That look, what will be the impact on India's companies? Ultimately, is this net result? Is this in the interest of the nation as an international global state? Government is also seized to the fact that we are a very responsible power. But conduct of foreign policy, therefore, courts don't step in to this area. Because it's replete, actually, in a state of war, we can say it's replete with a minefield. of undeliverables by the court.
Not just the ICJ, but also the Hague Court of Appeal says so explicitly.
Will record a short
Explicitly, my lord, says so explicitly that this would be. UK has suspended, my lord. Just see the letter written by 600 jurists, including 4 retired Supreme Court judges of UK, to the UK, on which, my lord, the UK government has suspended the export.
Action was not by the UK Supreme Court. It was by the UK government. Today, if the government of India does it, well and good. It's for them to take a call.
True. But if the government, if our government is not doing so,
Mr. Bhushan, only give me a minute. Lord, whether to decide, whether to term a particular action of one foreign country to be an act of aggression or genocide or act of defense, etc., that's essentially a diplomatic policy of the government. Lord, would the Constitutional Court take a call accepting that this is a genocidal act and therefore the treaty applies and therefore, my Lord, even the contracts are to be interdicted? Well, that would be very.
Invoking Article 32 of the Constitution has been instituted by former civil servants, scholars, activists, and experts in fields such as international relations, human rights, and policy analysis. Full stop. The petition seeks directions to the Union government to cancel existing licenses, permissions, and to halt the grant of new licenses to companies in India for the export of arms and other military equipment to Israel during the ongoing conflict in Gaza. Full stop. These companies, as the petitioners describe, include a public sector enterprise under the Ministry of Defense, Munition India Limited, and private companies such as Premier and private companies which have allegedly been granted licenses post October 2023. The petitioners claim a violation of India's international law obligations and of Articles 14, 21, and 51, bracket C of the Constitution. Full stop. Next.
As well as under the...
Yeah.
And the International Convention,
Mr. Prashant,
which India has ratified.
Supporting the submissions, or submissions of the petitioners, Mr. Prashant Bhushan, learned counsel, urged, has relied on the rulings of the International Court of Justice dealing with
I wasn't able to show your lordship.
We have relied on the well settled. We didn't go into the merits. Relied on the rulings of the International Court of Justice in regard to the conduct of Israel, allegedly into the conduct of Israel in the Palestinian territory. Full stop. The submission is that India is bound by international treaties which disallow the supply of military weapons to states who have engaged in war crimes, genocide. Full stop. In other words, the submission is that the continuation of the export licenses would constitute action complicit against the Genocide Convention and other international obligations to which India has assumed. Full stop. Next. The fundamental objection to the maintainability of a petition of the nature that is before the court is simple. It lies in the fact that both in relation to the conduct of defense and engagement in foreign affairs.
Is your lordship saying that law or no law that would be...
So conduct of foreign affairs, we are not dealing with defense, conduct of foreign affairs, the authority and jurisdiction is vested with the Union government under Article 162 of the Constitution, read with the parliamentary control in terms of, don't say read with, it's stop. Apart from Article 162 apart from Article 162, the provisions of Article 253 of the Constitution stipulate that Parliament has the power to make any law for the whole or any part of the territory of India for implementing any treaty, agreement, or convention with any other country or countries, or any decision made at any international conference, association, or other body. Full stop. Now, it is well settled that international law is that there's a presumption that international law is a part and parcel of national legislation of the law of the nation, and hence, unless it is specifically, unless the application of an international principle of law is expressly or by necessary implication excluded by the competent legislature. Stop. However, the basic issue which falls for consideration in the present proceedings is as to whether the court, by judicial fiat under Article 32, can issue a writ to the Union of India to cancel existing licenses and halt the issuance of new licenses for the exports of arms and military equipment to Israel. Full stop. We are affirmatively of the view that the answer to this question must be in the negative for more than one reason. Full stop. First, the grant of relief in the present proceedings is presaged on the submission of the petitioners in regard to the conduct of an independent sovereign nation, namely Israel, in the conduct of its operations in the theater in Gaza. Full stop. The sovereign nation of Israel is not and cannot be made amenable to the jurisdiction of this court.
We are not even asking.
Full stop. Hence, for this court to consider the grant of the reliefs as sought, it would inevitably become necessary to enter a finding of fact in regard to the fundamental allegations which have been leveled by the petitioners against the state of Israel. Full stop. Absent jurisdiction over a sovereign state, it would be impermissible for this court to entertain the grant of reliefs of this nature. Full stop. The next, the second aspect of the matter, which equally requires to be noticed, is that the petition seeks a prohibition against a cancellation of existing licenses and the issuance of new licenses for the export of arms and military equipment by Indian companies. We'll stop assuming that some of these licenses are now governed by contracts with international agencies, with international entities, including within the state of Israel, the grant of injunctive relief by this court would necessarily implicate a judicial direction for breach of international contracts and agreements. Full stop. The fallout of such breaches cannot be appropriately assessed by this court and would lay open Indian companies which have firm commitments into proceedings which may affect their own financial viability. Full stop. The provisions of the statutory provisions in our law confer sufficient power on the union government to act in such cases. Full stop. For instance, prohibitions can be imposed by the union government under the Foreign Trade (Regulation and Development Act, as well as under the provisions of the Customs Act 1962. Full stop. Whether in a given case, any such action is warranted is a matter which has to be decided by the union government, bearing in mind the overall economic, geopolitical, and other interests. of the
Diplomatic
nation.
considerations.
In fact,
Full stop.
Your Lordship should say, bearing in
Full
mind
stop.
the international law on the subject and the conventions which India has ratified.
In taking an appropriate decision, the government bears into account all relevant considerations, including the commitments at the international level. Full stop. The danger in the court taking over this function is precisely that it would be led into issuing injunctive reliefs without a full and comprehensive analysis or backdrop of the likely consequences of any such action. Stop. The restraint which courts, the self-imposed restraints on courts in entering into areas of foreign policy is thus grounded in sound rationale which has been applied across time. Full stop. For the above reasons, we have come to the conclusion that the reliefs which have been sought in these proceedings are not amenable to the exercise of judicial remedies under Article 32 of the Constitution. Full stop. We clarify that the observations which have been made in the earlier part of this order are not intended to reflect any opinion by this court, either in the conduct of foreign policy by the Indian government, or for that matter, by any sovereign foreign nation, which is not amenable, which is not subject to the jurisdiction of this court. Full stop. The petition shall accordingly stand for the above reasons.
No, there is one application that will be disposed of. One application pointer that will be disposed of.
Grateful to you.
Yes.
Thank you. Thank you.
Your Lordship, there is a already settled. Yes, Your Lordship, there is a already settled position of law. Law will be law until it's gazetted notification.
But who's your client? What is your locus?
We are concerned only with the rule of law and process of the law.
Let somebody, you are saying that those rules of 93 were notified by the government of Bihar in 2023. You may be right.
Yes.
But who's your client? He's some lawyer who's filing out PIL.
Your Lordship, we are only concerned because
if somebody is in a given case, they have their remedies in a criminal court.
Even Your Lordship, the Honorable High Court already
lawyers enter into this.
High Court already recognized there is a defective notification, Lordship. If Lordship not will consider that notification will be continued, Your Lordship, and until somebody not come.
But how is the lawyer concerned with all this?
Because Your Lordship, we are concerned with the rule of law, Your Lordship, and we are.
There's always the behest of somebody. That's why the High Court has rightly rejected it.
Your Lordship, there is substance is saying the law will be applied retrospectively.
There's nothing on this. Item 14, thank you, dismiss. Item 14 is to be tagged with Gamescraft, no?
Yes, Lord. I'm appearing in item 14.
And 38 also, I think.
Yes, Lord. And the matter is coming up tomorrow.
We'll just notice and tag.
Lord.
Item 15.
My Lord, may I just make one more request, my Lord? There were two other matters which are to be listed today, which are to be tagged tomorrow. All
right, tomorrow, when it's called out, you mention it.
My Lord.
Item 15. 15, such a big crowd.
That's for the next one.
Oh, I see. They all sort of, all anticipatory mobilization. Yes.
I'm appearing in item 15, Your Lordships.
Ma'am, NEET is over.
Your Lordship,
Now admissions are being made. Now you said you should have been given more time because you had there was a paper mix up.
there are 3 reports, Your Lordships, I want to highlight. There are 3 documents, Your Lordships. There is one report by the city coordinator dated 6th of May.
Now it's too late in the day to
Your Lordships, the counselling is still going on, Your Lordships.
Not can't interfere now.
We are just 7 students, Your Lordships. The counselling is still
The
going.
court has applied its mind now. We have to close it.
Your Lordships, just one point.
Yes,
Your Lordships,
ma'am.
just one.
Sorry, ma'am.
There is a report of the Deputy Commissioner which is recommended for the retest, Your Lordships.
No.
That has not been considered.
Now, at this point now, no more eating.
No, Your Lordship, this was on 18th.
Children are tired now.
Your Lordship, this was on 8th of May, Your Lordships, and that has not been considered by the NTA, Your Lordships.
Thank you, ma'am. We'll close it. Yes, discuss.
Obliged.
Plus 37.
I'm in 16. But anyway,
Yes, I appear in 16.
All connected matters to 16.
so these are people who were appointed
We are on the
4 years ago, etc.
5 years.
Subject to.
You are for the selected candidates.
We are for candidates who would come in.
We are selected, we are working for last 5 years. By virtue of the DB's order reversing the single bench, the effect will be, Lord, we will be pushed out. This is not a scam case, Lord. There's no
result. This is the ATRE. This is the Assistant Teacher Recruitment Exam.
My Lord, the short question really will be whether when you enter in the reserve category, whether you can migrate subsequently. Now, we are all
the question is the
merit
interpretation
came
section
in the
36.
general category. The people who came in on the reserved category with concession marks and
Who are
put
your
exams.
clients really? Because we have seen the judgment.
General.
But frankly, I read and reread it actually today. But who are your clients?
We are general. We are general.
On merit.
You're all together in one group.
We are in
All
one.
right, then we'll hear just for any one person, Mr. Who would like to just tell us in 2 minutes.
2 minutes without reference to papers.
Can I just make one submission?
This is assistant teacher recruitment in UP, Milord.
UP Basic Education.
So the 2 qualifying, Milord, benches, one is TET, Milord, and one is BD or BEd, etc. So there's no issue on that. So,
That doesn't matter. ATRE, exactly.
ATRE.
no, Milord, for these minimum qualifications, even for TET, Milord, the benchmark for reserved is lower and the benchmark for unreserved is higher. But I am not, Milord, making any grievance out of that. After this qualifying, we go for selection. When we go for selection, it's an exam called, Milord, Assistant Teacher Recruitment Exam, ATRE. And even in ATRE, Milord, the qualifying mark for, Milord, unreserved is 65, while it is 60 for them. So, Milord, when this happened, Milord, we were eligible. If you get 66, we are eligible. If they get, Milord, 61, they will be eligible. But then the 65 and 61 also, Milord, will be counted at some stage. So when we got our positions, Milord, in the so-called roster, we got our positions, Milord, in the unreserved category. General category.
You're all general category.
We are all general.
We are all qualified. We have all obtained more than the cutoff. It's not that we are waiting list, etc. We are not for those Calcutta matters, etc. So we were appointed, Milord, we are serving. So some people said that, Milord, if you are reserved, can you occupy only a reserved seat? Or can you also occupy, Milord, an unreserved seat?
If a reserve category candidate gets into the order of merit, then you occupy.
No, this was only because of concession marks. They got in only because of the concession marks. Not
that might be, Milord.
But it's weightage.
I'm going to show you.
For the quality marks.
Those of the reserve category got above 65.
Explain it maybe.
Have been appointed.
Yes.
In the reserve category.
In general.
No, not in the reserve.
65, but who are just eligible because of 60%. Lower cutoff.
Yes.
So they come in because of the reserved category. So that's the
So in
question.
other words,
Whether having come through the reserved category or the lower relaxed mark concession.
60, that is 60.
60.
So if you have 61,
Can you again get?
Milord, the benefit of saying,
I will go and take, my lord, the unreserved seat and push out those who have got 66.
So they are not above 65.
They're not. No.
Those above 65 have been appointed.
Correct. So it is, my lord, the game between.
They only came in on weightage.
So the other way to look at it is this way.
Because of the appendix one. Oh, that's what it is.
So this is, my lord.
Disclose to your
Make sure one to those rules. Rule 14 I saw in the judgment.
Yes, correct. Schedule 1.
And then you have appendix 1.
Appendix 1.
Now, at what stage do the quality points?
Yes, at schedule 1 stage. At schedule 1 stage.
How does it work? Because frankly,
That's the
I was
third
a little
stage.
unclear on where the quality points.
After the reservation is done. And then, my lord, the advertisement is.
That's the error.
Yes.
And subsequently, they're allowed to migrate. This is what we're objecting to. May I just tell your lordship what the controversy is? There is 70% are
There is an ATRE examination. A general category candidate qualifies ATRE at 65. A reserve candidate qualifies ATRE at 60. Once you qualify, you are in two lists, the general list and the reserve list. What the state government did, any reserve candidate who had 65 and above was only considered in the general category. A reserve candidate who had less than 65 was not considered in the reserve category and kept reserve.
Not considered in the general category.
General category kept reserve. Controversy arose whether this ATRE is only a qualifying examination or is it part of a process of selection? Because if it is merely a qualifying examination, then you can't decide reservation on the basis of qualifying examination. That is a concession which is permissible. Like we had in TET, the case is completely covered by Vijay Sampla. Exactly. So then after you pass the ATRE stage, then you come to the stage of selection process.
First, everybody appears for the
ATRE, and it is a sort of a.
If you are a reserve candidate.
Yes, you are shortlisted for the next stage.
Right.
Now the next stage is
Appendix 1.
Next stage is Rule 14, Sub Rule 3 and 2, read with Appendix 1. There are various qualifying marks which are added. How much you have got in your first academic standard, second academic standard. ATRE also 20% of your total ATRE score is added in your total, 60% is added in your total score to make the merit list.
No concession there.
ATRE carries 60% weight.
Yes, no, just kindly now have the schedule.
1 second.
1 minute.
We're just trying to understand the broad.
So page 19 is the schedule.
If the judgment was clear, we wouldn't have had.
Just see page 19, which is the schedule. Page 19.
Lord, it will have to be heard, Lord. We are being pushed out after 5 years.
Page
confirmed service. The Lordship will hear it. That's all we are saying.
Correct.
And it's reversal, Lord. Single judge is reserved by.
It's the controversy is very narrow.
Yes.
Now the question, just kindly see page 19, how the merit is to be made. If your lordship, it says high school percentage of marks 10 upon 100, intermediate marks are added, graduation, BTC, ATRE, teaching experience, etc. All that is added at page 19 to make your final merit. Now the question is that it is at this stage that reservation is to be applied.
That's the question.
If my minimum marks are more than the general candidate, then I have to be considered in the general category. And that is what now the learned single judge said, the division bench statement. That is precisely what the division bench states. You cannot just put me in a compartment of reserve on the basis of that qualifying examination, which is not a process of selection. This issue your lordship decided first in Jitendra Kumar, and then the identical situation happened in TET. TET was merely a qualifying examination for the purpose of further appointment subsequently. So the issue arose before your lordship that a candidate who qualifies TET with a reduced standard in the reserve category, when he competes, when the post is advertised, can he migrate from the reserve to the general category if in that process of selection, his marks are more than the general candidate? Your lordships have emphatically answered it, relying on Jitendra Kumar's judgment, saying that is only a qualifying standard. And 20% of the qualifying marks are to be added in your total score. And therefore, or 60 here or 20, whatever. So 20% or 60% of your marks are to be added to your total score. And therefore, it is the total score which is the selection process.
So you take 60% of the ATRE marks.
Correct.
Plus
Whatever it is.
quality, yes, whatever it is.
Plus add your high school,
add the quality points.
Correct.
Then draw up a then
Correct.
And thereafter, any candidate who is meritorious enough to get into the
Yes.
will go in as an unreserved.
Correct.
That's right.
As for Millets, just to add two things, under the well-settled principle that a meritorious reserve category making it on his own merit to be counted for. Now, Millets, your lordship said in TET, as my learned friend just pointed out, that insofar as TET, then Millets also had two facets to it. It was a qualifying examination and then also determined merit along with other factors. Your lordship said very clearly that the first part is a qualifying part. When it comes to selection, a level play field is the expression your lordships repeatedly use, and say a level play field has been given.
So this is
fact. Where the learned single judge.
All appointment letters say subject to result of the petition.
What we want to say is this. Yes. The judgment needs to be in the sense that the law needs to be correctly stated in our judgment. Right?
Correct.
What we'll do is that maybe if you can, all of you can give us one small compilation of not 2 to 3 pages of your submission, because the point is very narrow.
Yes.
And likewise over here, we'll write a judgment and clarify the position in law.
Yes.
So can we keep it maybe today's Monday? Should we keep it next Monday? Will you be able to circulate your notes?
Your lordship may just your lordship may just note 2 judgments and just see those 2 judgments. Just 1 minute.
So there's so many difficulty. But with the number of counsel, we just say that nodal counsel on one side. If you can put together not more than 2 or 3 submissions, otherwise it will become.
May I make a submission request? This 2017 1 SCC page 350. 2017 1 SCC 350. Beyond that, we need to argue nothing. It is settled here.
No.
2017 1 SCC
because Sankala is distinguishable. There's no TET marks involved.
It is.
In respect of ATRE, that's the only difference.
That's the only difference.
Of reservation, my lord.
What is the one second? What did the single judge do?
Single judge said TTE is all right, but the ATRE you cannot get concession twice over. Yes. In the ATRE also they've been given concession. So the single judge said if they've taken the concession at the ATR stage, then they cannot claim migration afterwards and decide in our favor. Division benches reverse that.
Now, what is the nature of the concession which they took at the ATRE?
The two cutoffs, 60 and 65.
60 and 65.
Yes, that's right. They had not in the final. Even in TET, but we are not basing our case on TET, which was merely qualifying, while ATRE is a part of selection.
Selection and merit, and it's an open exam.
Not advantage of.
I'm sorry.
Migration is a rule.
Just one second. Let's see Mr. Dwivedi.
No, I'm sorry.
When the single judge says that ATRE examination and the appendix quality point marks, they are together forming one recruitment process. They are not disintegrated. It's not like the TET eligibility. So this ATRE examination, when it grants a relaxation, then it is based on that computation done along with certain other quality point marks that are added. So this is one process, and having come in
on the reservation
on the basis of relaxed marks, now those who are below 60% or 60% who have come in, they can't migrate to the reserved category.
The general category.
Because at stage 1, they had to put up with a less qualifying.
It can't be
less threshold of 60 as opposed to 65.
My learned friend relies on Sankla's case that has been considered by a 3-judge bench.
Yes, Malaj, 3 judges affirming this.
Case, kindly have this.
Yes, please. Malaj, 3 judges.
2 copies.
3 judges on this point affirm it. 3 judges say this.
Just hold on.
Yes, because I have that right here.
You were not citing it so far. And now you want to.
Citing a judgment which is already mentioned here.
Para 20 and 21, they have said that you can't migrate if you have come in like that.
That is the case of, in any case, TET, we are not taking advantage. We are not taking advantage.
Malaj, in this case, it is only there is no marks given to it. That is the rationale. Please see that.
Weightage has been given in the ATRE.
TRE and they are integral.
Please see para 18, Malaj, para 18.
Back from para 19.4 to 21.
18 is important.
18 is important.
18 answers it.
See the rack.
Also.
Well, para 18.
Your lordship may see the rack.
The point is this, we'll probably have to hear this again. The point is really this, that once you have qualified on the basis of the lower threshold of 60% for reserved categories, then you can't say that, well, I'll still gain into the unreserved category based on the quality point.
That's what the lordships have said, because it's not part of the selection.
Already got the benefit.
The distinction here is
The question is between horizontal and vertical application of reservation.
The whole purpose of reservation is to give the reserve candidate an opportunity of making it to the final select list. So this is not a process of selection. This is in the nature of a concession. In Jitendra, the jurisprudence is discussed in Jitendra.
Stay the operation.
Monday week.
My SLP is also listed 39507. Could my lords list it along with this? SLP 39507.
On 23rd September, bearing in mind the urgency of the need for filling up posts.
No, posts are already filled up. It's already working.
And they are protected.
The need for certainty in the case. The
Let there be a status
be listed at this stage for hearing and final disposal. Full stop. Mr. Prashant Shukla, instructing advocate on behalf of some of the petitioners.
Yes.
Mr. Prashant Shukla on behalf of the petitioners and
Mandeep Kalra for the response.
Mr. Mandeep Kalra for the respondents shall act as nodal counsel. They shall put together, preferably, one set of submissions on behalf of the petitioners and one set of submissions on behalf of the respondents, not exceeding 7 pages each. Full stop. The petition shall be listed for list on Kardo. So, yeah, file it. The petition shall be filed
immediately after the fresh matters.
File on or before.
High Court has given a status quo that this session you will continue. That status.
Therefore,
we've already been there for the last 4 years.
March.
Yes, we've been there for 4 years already. So
that's why that session benefit there.
Correct. There's also one important fact. Lord, there's also.
Actually, the judgment is very.
Yeah, the Honorable Single Judge makes it simpler to understand.
We'll now, next time, what we'll do, I didn't read the single judge. Yes. We'll read the single judge, I think.
Because here I agree with your Lordship, although the conclusion is right, but it was confusing.
I am instructed that the state wants to say something which might.
Can I just make one humble submission? SLP number, the diary number 39507 also needs to be listed along with this.
You're not filing an independent SLP, right?
No, not.
All right.
Well, it's item 37.4.
Ms. Aishwarya Bhati, when the ASG appears for the state of Uttar Pradesh, the state would also be at liberty to file its independent submissions not exceeding 5 days.
My lords will order a status quo in the meantime. We've been there for the last 4 years.
What will happen between now and the 21st?
Nothing will happen. They are secure till March. They are secure till March.
All of the list should not happen.
They are secure till March.
All that we are saying. It will
Let there be a status quo.
Status quo. 69,000
All right.
people.
Fresh steps for redrawing the list in pursuance of the assumed directions of the division bench shall be held in abeyance.
Oh, my lords.
Your plan. Very good.
That was item 37.
By the single judge also. The list is squashed by both.
No, but
single judge also. Therefore, in any case, that has to be
My
lord,
for appendix item 37.
They will not give effects, Let the process continue.
Till the 23rd.
It won't be wasted. That time in drawing up as per appendix 1. It means that list will be drawn up.
No,
my lord, J. Sai Deepak sir wants to appear online.
Lord, there is one important fact. Lord, even now, with all the faults pointed out by other side, 70% belong to reserve category.
I'll tell you, Lord,
of the total recruitment, Lord, 69,000.
I'll give it right now.
70% belong to reserve category.
My lord, I'll tell you, Lord, what will happen.
Can I make one non-adversarial submission, please? Just one non-adversarial submission.
Only as per appendix 1 and nothing else. Now today that entire process will get derailed because the losing of the job is in March 2025. Today what is required to do the list, what prejudice will be caused?
Your lordship may say it may not be finalized.
It will open Pandora box, will
Not be given effect to months.
But that's the whole issue is that appendix.
Yes, the list can be prepared and not be given effect to.
My lord, may I mention diary number 39507, identical SLP, my lord, same order may be passed.
Item 17.
Wait, please.
37 also, Lord, these are.
Yes.
17
Appearances may have to be taken. My colleague hasn't filed.
17 raises a question that is being considered by this court, Lord, as to what is the context and contours.
You're facing prosecution for cheating, forgery of 1,301 crores. The Punjab.
Go on. I'm not saying that would have any. That would be.
Why stay the 138 proceedings?
I'm sorry, not.
It's covered by judgments in Mohan Raj and Goenka.
This question is being considered. Just kindly have para 27 of P. Mohan Raj.
Let the trial go on. Why should they?
Bear with me for a moment.
And the moratorium against in the 96 proceeding will not affect the 138 proceeding.
No, bro, with respect, it does. Your lordships have held so in Mohan Raj. Kindly have para 27 of Mohan Raj, bro. It's completely in my favor. Please have Mohan Raj, bro. I just pass on.
It says when any application is filed under 94 or section 95, any legal action or proceeding pending in respect of any debt shall be deemed to have been stayed.
But may make a respect.
Not in respect of any debt. It's for a criminal offence.
Just bear with me for a moment. But in para 27 of P. Mohan Raj, your lordships interpreting section 96 of IBC have held 138 is barred, is stayed. I'm covered by that. I'm covered.
What do you have to say about Goenka's case? Goenka has considered.
I'm sorry, Goenka, my lord, I'm sorry to be obliged. Goenka considers section 14 of the IBC. 14 in terms of content is very different from 96 IBC. 96, when it comes to not personal insolvency, is all encompassing in respect of all debts versus 14, which is narrower in scope. 96 is wider, which is why in para 27 of P. Mohan Raj, can you pass it on to P. Mohan Raj, no losses have held there are 138 proceeding, which is essentially a civil proceeding, but given the color of a criminal proceeding, not is barred. Just bear with me for a moment. I'm covered by that. So, not para 20.
Give us a copy of Mohan Raj.
You can't do this. I'm sorry, bro.
ये क्या है भाई? हाँ, ये क्या दे रहे हो? You want us to go to the library and get it or what?
Sorry, we can't do this.
हाँ, कहाँ practice करते हैं?
My apologies, Lord. Good losses have it tomorrow, Lord.
All right.
I'm sorry. I thought not we have a compilation, we are passing that on.
Yes.
I'm so sorry.
We'll take it up on Friday.
Friday? Deep reply. I'm sorry for the
no.
Deep reply.
My lords, this FIR pertains to the batch matter, which is already pending before my lords.
But we'll issue notice and stay. Yeah. We'll issue notice and stay. This is FIR, that next FIR, 54 of 23.
Yes, my lord.
So that we'll issue notice and stay of further proceedings in the FIR.
It may be tagged with the FIR number 28 of 2020.
It has to be tagged with which one?
My apologies. With writ petition number 28 of 2020.
Go check that one.
Rajendra Bintal, the cast title.
Yes.
Please, your lordships.
Where is that report you're
We have e-filed the latest report. He submitted it. We also have copies.
Have copies? Just give us copies.
With email. We've emailed. There were 3 issues raised on the last occasion, my lords. Apart from the e-filing status, your lordships had also inquired about the number of cases where the delay was of more than 200 days.
19, no?
And the cases where the monetary value cases.
Delay of 500.
Check these 3 copies.
Yeah, Ms. Bakshi, can we just read it over the week and then Friday we can keep this? Yeah, हम तीनों को circulate कर दो. And which are the high courts where you're confronting a problem? If you can just
that
tell
is
us.
para 5.1.3.
I think Nagpur bench you said you have, and
Yes.
Chhattisgarh.
Guwahati, there was a problem which is now solved, but Chhattisgarh, there is a facility is not available. My lord, I'm reading from 5.1.3.
Yes.
And then the field authorities in Andhra Pradesh, Telangana, and Chandigarh, there is a problem when the documents are voluminous. Then Nagpur bench, Jharkhand and Jammu and Kashmir High Court. This is where we are facing problems.
What about the Supreme Court? Are you now e-filing all your appeals in the Supreme Court?
My lords, therefore, we have a large number being filed over here.
Large number means how many?
What is the Supreme Court?
Ms. Bakshi, we'll keep it on Friday. Just have a look
Yes.
at what happens to the Supreme Court. We'll also study this and pass a small order on Friday.
Yes.
I think it's for wasting time right now. We are also held back today a little bit, so we'll take this up on Friday.
21.
20 to delete हो गया था.
Let's look at the last order passed. This matter.
Now, what remains here?
It worked itself out. There's only one small issue I must bring it to the notice of your lordship. The High Court passed an order, the division bench, noticing the single judge's order that in due course the Andaman administration will frame a scheme.
Yes.
But then we are bound by the government of India. DOPT says we can't frame a scheme and so many objections have been raised. The matter stands there. And the division bench will disposing the matter said if they have a grievance, they can certainly come back to the High Court.
Now,
Therefore, your lordship
14th August 23, we had recorded the contents of your additional affidavit, right? Our order 14th of August 23.
But that came in the context of a contempt appeal.
Right.
Therefore, the contempt appeal, whereas...
So what we did, we closed all the contempt proceedings and substituted it with our own order.
Yeah, affidavit.
Where is that order?
Initially, I think the authority filed an application
Page
for
11.
extension of time.
Page 11 of your MA.
If you also look at paragraph 11 of that order of August 14, 2023.
Right.
So
the
we have
administration
now,
has, during the pendency of these proceedings, taken steps to withdraw the offending clauses. Order 2276, enhanced wages shall be implemented with effect from 1 September 2017.
that's been complied with.
Arrears payable from 9 September 2017 to 8 May 2023.
All that is fully done. The next part of it. Moreover, it's been stated the regularization would be framed in terms of statement made before the division bench of the High Court. This has been clarified in the additional affidavit. We said so in the additional affidavit. We are subject to DOPT's giving a clearance for this scheme.
Now, where is it lying with where is it pending with the DOPT? Mr. Attorney General, get it cleared. What is the difficulty now? Small thing remains. You use your good offices.
There is some issue. I went back to DOPT and there is some issue. If they have to do it, then it cuts across a large number of.
To comply with now the statement.
What happened is after the order, we filed an application for extension of time much before, but then now that's been complied with, the application doesn't have any relevance today. But the question whether in a contempt proceeding.
But why have you come here actually with an MA? What is your prayer in the MA?
The prayer in the appeal was extension of time at that point of time. We needed some more time to comply with that. The question of payment, etc. That now that we have done that, that's become academic now. So the application is infructuous now. No, you are taking time for regularization of the scheme. No, your lordship did not say, except there's no direction with this, because there's a contempt proceeding and a contempt appeal.
So then they're not pressing this today.
My lord, may I submit, my lord?
For extension, I don't need to proceed because we have complied with the question of payment.
Payment. Then
we have
close
complied
it.
with.
Then we close your MA.
That's what I'm trying to point. As far as the other matter is concerned, that may not be subject matter in a contempt appeal.
My lord, there are two parts, my lord, of my lord's order of 14th August. My lord, may kindly see paragraph number 10, my lord. With regard to regularization, my lord. The administration has made effort before the ministry. My lord, may kindly read para 10 onwards, my lord. Administration is not at fault, but the ministry, my lord, because they have placed the proposal. And the proposal is very clear, my lord. Administration has placed very clear proposal. Ministry by a letter dated 13 December 2023 saying that it cannot be done. That is one of the MA they have enclosed, my lord. That MA is fixed today, my lord.
The High Court's order, the SLP, the appeal, contempt appeal, the High Court's order.
So it is only with
From this order also. In the context of a division bench passing an extraordinary order.
Right.
That's
That
right.
we have set aside.
Correct.
Now the only point which remains is the regularization. Because we have said, moreover, it has been stated that the regularization scheme would be framed in terms of the statement which was made before the division bench of the High Court.
That's true.
Have you framed the scheme like that?
That's why we have to go back to DOPT. We can't do it ourselves.
So now tell
we are governed by DOPT.
Tell DOPT to sanction it now. What is the difficulty?
No, DOPT has explained why such a scheme cannot be framed. Therefore, in a contempt appeal, whether this matter would be gone into is what I'm trying to point.
No, but we have, Mr. Swalsa, Mr. Attorney, we have
I
said.
understand there is an issue, but whether this court will go in this contempt appeal. But at that point, we're not in contempt.
DOPT is bound by our order.
No,
DOPT is now bound by our order also.
No, there was no issue before your lordship as to who will frame the scheme. We filed an affidavit saying that we are bound by DOPT. We have gone to the DOPT and the DOPT is looking into it. And therefore, the question before the High Court was only about compliance regarding payment of this compensation, etc.
No, my lord.
Regularization was open. The division bench said, I'll point out the earlier order passed by the division bench. I'm sorry, Lord.
If we grant you time for this purpose,
yes,
and DOPT has already taken a decision, and now you are in a fix.
That's
how time is going to solve your problem.
No, I won't be the Andaman.
Come out with some solution how to deal with the report or
the
view of the DOPT.
The Andaman administration cannot solve the problem today unless
if you don't press this, tomorrow the other side will come with contempt.
No, there won't be a contempt of your lordship because see, I've travelled here in a contempt appeal.
Then why are you pressing the MA? We'll record your.
No, I'm not pressing that application.
My lord, they have filed a new MA, my lord. They have filed a fresh MA whereby they, at page number 6, they have given the letter of the DOPT, 13th December 2023. My lord, may kindly
this court.
Where is that MA?
My lord, kindly see that MA, my lord.
That's true. We filed an additional affidavit.
There is a letter because administration has made all attempt to comply the order. But the ministry in letter dated 13 December 2023 not at all consider the recommendation of the administration. And they say that in terms of the 7th October 2020 notification, we cannot comply. Whereas 7th October 2020 is for implementation of the judgment of Uma Devi. So, my lord, that has got nothing to do with this. Now, my lord, kindly see.
We don't have that MA, Mr.
I'm so sorry. It was only asking for extension of time.
No, my lord. 2 MAs are there, my lord. Extension of
one MA and an additional affidavit. There was only one MA.
No, my lord. 1 MA is there. 2531. 25313.
Where is that MA, by the way?
2531 of 2023.
There was an application for extension of time.
Page number 6.
Yes, 2531 we got. Page 6.
in page number 6, my lord. That is the letter of the ministry, my lord. That because of that, administration is unable to culminate this scheme, my lord. Scheme already administration has proposed.
So you wanted 3 months time for extension?
No, that is for compliance with the payment.
Now the present application for extension of time for further 3 months to comply with the orders dated 14 August 2023 of this court for taking action in compliance with inter alia directed in para 12 of the order of 14th of August.
We came in November 2023. By that time, the question of computation and payment had not happened.
Now you have paid.
That's right. Therefore, the application
made,
become
Mr. Binoy Kumar,
My lord. My lord.
Payment has been made to your client?
Payment has been made, my lord. Payment has been made.
That part is over.
That part is over, my lord.
Fair enough. Now, what about the regularization, Mr. Attorney General?
My lord, they have filed a petition.
Now you have to sort it out with the DOP.
In page number 6, they have annexed a document of the ministry.
It's not a question of a few employees. And then it goes in fact, today there are a large number of matters coming from various states vis-a-vis Uma Devi's implications. Uttarakhand, UP, I've been appealing.
Then simply close the MA, let them pursue proceedings in accordance with law.
That's right.
No, my lord. My lord has recorded on 14th of August.
It will be heard on his own merits. Matters will be placed, facts will be considered.
No, my lord may kindly consider my lord's order at paragraph number 10 onwards, wherein the administration.
MA, Attorney General says that we have made the payment which is undisputed and he is not pressing the MA any further.
No, my lord. There is a second MA, my lord. In that MA, they have said we cannot complete.
There's one MA.
My lord, I have
an additional affidavit which probably thinks affidavit.
That will be additional affidavit.
No, my lord. They have filed it. They have filed it on 5th of January 2024. A copy was served upon us, whereby they said ministry-wide letter dated 13 December 2020.
Mr. Attorney General, 5th of January, what have you filed?
Yes. Saying that ministry has rejected.
Give it to us.
What is it? It online. It date.
Page number 6, my lord.
Letter of 13th of December 2023 of the Government of India and the Ministry of Home Affairs.
That's 13th of December 22.
Why don't you do this? We will close it insofar as the Attorney General is concerned. If you feel that you have any further cause of action, you pursue your remedies in accordance with law.
My lord, since my lord, only one thing, my lord.
Ministry a party to the Government of India, Union of India party?
No, my lord.
So they are
No,
not
my lord.
parties.
No, my lord. It was not a party. Not a party. My lord, only one.
It was even hinted to the division bench. They're saying it has to go to UOPT, but then of course never become part of the record.
My lord, only one thing, my lord. Administration has recommended now ministry, my lord. If my lord sees the letter of ministry, it is contrary to my lord's order and the administration recommendation.
Independent cause of action because Government of India was not a party to the proceedings.
But my lord's order is there, my lord. Administration is the employer. They are ready. They have sent the scheme to the ministry.
Independent concerns. DOPT has independent concerns.
My lord, kindly see. Then, my lord, after the orders of the court, if we did not, then where we can agitate our grievances, because already the court has passed an order in our favor.
For the High Court.
Old order. Show me the old order. Division bench, first order.
And my lord, the ministry's reasoning is totally contrary to the order of the court. The court said in terms of 7 June 1988 office memorandum. Ministry said in terms of the Uma Devi's case, we cannot frame a scheme. That was not, never administration said them to frame a scheme under, in terms of the order of the Uma Devi judgment, my lord. My lord, if my lord once read the order.
Just say that the payment, which was envisaged in paragraph 11 of the order of this court dated 14 August 2023 has admittedly been made. Stop. This is not in dispute. This is not disputed by Mr. Gopal Binoy Kumar, then counsel appearing on behalf of the workmen. Stop. The Attorney General for India, Mr. R. Venkatraman, also states that payment has been made.
Yes, yes, yes.
Full stop. As regards the issue of regularization, it is common ground that the Union of India, that DOPT, that the Department of Personnel and Training of the Union of India was not a party to the earlier proceedings. That's correct, right? Stop. In this backdrop, all that needs to be observed at this stage is that if the petitioners have any subsisting grievance in regard to, if there's any subsisting grievance in regard to the scheme for regularization, it would be open to the workmen to pursue their claims in accordance with law. Full stop. The MA filed by the Union of India,
yes,
accordingly, is disposed of as not test at this stage.
2023 of the ministry, my lord.
Item 22.
Item 22, please enable the camera, sir. Kushal, sir.
Yes. Had directed the NCLT to complete the proceedings by 31st of August. But then NCLT, the pleadings are almost complete there. They have fixed the matter on 20th of September now. So that's, I think that date will be concluded. So one more date I would request.
We can keep it maybe a week later.
Well, okay.
Because the proceedings before the NCLT are listed on 20th September
2024.
2024.
The instance of the applicant, so no more adjournment should be made.
No, my lord. In fact, this suggestion was made.
We'll take it after a week thereafter.
Yes. No problem. My lord, may kindly give little more time because then in
2 weeks thereafter.
Okay, yeah. 2 weeks, my lord. Deeply obliged.
23.
Deeply obliged.
Ms. Bhatti,
Whereas we've issued the GO, kindly call it after 2 weeks, the payment would also be made. I have given a copy to my colleague.
23rd.
On the joint request of the Learned Council, list on 23 September 2024, by which date the dispute is expected to be resolved.
Yes, ma'am. We've already issued GO. We'll make the payments. Great.
GO has been issued, no?
Yes, my lord.
Then why do we have to keep it pending?
Just may take it on record and discuss.
Lordship may have it on 23rd, my lord, because Lordship may have it in 23rd.
Who has issued the GO?
The government, my lord, the state of Puducherry.
Lordship may have it on 23rd, my lord, because only then we'll get the payment. Lordship may have it on 23rd.
All right.
May I please, my lords?
The court wanted me to circulate a note and then we circulated a note, there is a response, there is a reply. It's as if the pleadings have been completed in his matter.
Yes. How long would you take?
My lords, I'll just take 5 to 7 minutes. I just have to show
Today we were held back by the Calcutta matter for the whole of the first session.
I know that.
Yes.
We've got about 20 matters to finish our board today. So we'll take it up next week because otherwise this will take us up right through to the end of the day. We'll at least be able to finish 15 matters in the next 20 minutes,
Now that she is retired, the question may require consideration if at all, or want to still
because my lords,
extend a helping hand if that's possible. She is retired now.
that she was the senior most serving army officer.
He'll deal with the grievance. He'll deal with the grievance, but not today.
But my lords, we give a fixed date, otherwise the matter.
We'll do that, yes.
Obliged. My lords, we'll have it next week. 17th. Obliged.
We lost, may not have it on 17th and 16th, 17th.
All right, Friday after that?
11th.
What day?
No, this is actually a fresh matter. But it's an order of the NCLAT dated 9th of July 2024. The order was not uploaded, my lord, so when it came up before your lordships on the first time on the 12th of August, There was, my lord, 2 files, so your lordship, my lord, kept it on another date. It's come up, my lord, subsequently, but it's coming up fresh. The short point is this, my lord. An application is moved by the liquidator to include in the assets of the corporate debtor property that admittedly belongs to the promoter. Admittedly. That application is first allowed ex parte. It is set aside, my lord, subsequently. When it comes up the next time, my lord, I am now arrayed as a respondent. I being the promoter, I'm now arrayed as a respondent. Separately, I have also filed an application to implead myself in the proceedings. The application of the liquidator, my lord, where I am impleaded as a respondent, is allowed again by the NCLT. I challenge that order before the Honorable NCLAT. NCLAT says you are not a person aggrieved because although you are a respondent in the liquidator's application, you have not filed an independent appeal against the order dismissing your impleadment, disposing of your impleadment. NCLT disposed of my impleadment, saying that the application of the liquidator is allowed. That is not wrong on merits. I'll come to that. But not at this stage, I am first ousted by the NCLAT, saying that while you have appealed the liquidator's application order, you have not appealed the order disposing of your intervention or impleadment.
Right.
That has to be wrong, Lord. I'll show your lordship paragraph 8 to 10. Now, that's the main appeal. Now, subsequently, my lord, the order of the NCLAT, as I said, is 9th of July. We have been before your lordship on 3 dates from the 12th of August onwards. My lord, it wasn't able to reach on the subsequent 2 days. Acting, my lord, in the meantime, and despite our letters, the liquidator has now put these properties to sale. So, my lord, today I'm requesting notice in the matter and a status quo. These are admittedly, my lord, assets of the promoter, not assets of the corporate debtor, not amenable to be included in the liquidation estate under Section 36. And to date, my lord, by the NCLAT, there will be no hearing on merits.
You are for the Union Bank.
I am for the Union Bank, Your Lordship. Just two.
Are these properties of the corporate debtor or of the promoter?
It belongs to the promoter, mortgaged to us. So the properties are mortgaged to Union Bank of India, and we agreed to relinquish that or add it as part of the liquidation estate so that the hospital can be sold as a going concern to maximize the value. So it is wrong to say that the right of the promoters exists on the land. It's in fact mortgaged to us. We are lender to the corporate debtor, and we are also
corporate debtor is a hospital.
Hospital, and land belongs to the promoter, mortgaged to us.
So you would be able to realize your mortgage security ordinarily.
Yes, otherwise you can proceed in the surface.
So what you did was you gave up your security.
Yes, sir.
And on the condition, once you gave up your security, that was on the assumption that the entire hospital would be sold as a going
concern
together with the land.
To maximize the value, and therefore 36 crore rupees, it was auctioned and sold, not before the matter was listed. It was in fact auctioned in way back on July, 12th of July, after NCLAT order.
I am the caveator, madam.
Under surface, proceedings can be taken out.
May I say one thing, madam? I am the caveator, madam. May I say one thing, madam? Liquidator, madam. Just to address your lordship, madam. I am appearing for the liquidator, madam.
Yes, Mr. Satyanarayan.
I am grateful, madam. Madam, also, madam, they have given the property to the corporate debtor 19 years registered lease agreement, madam. They have given the property, madam. One more thing is that, madam, already, madam, this honorable court, madam,
registered lease.
Yes, registered lease, 19 years lease, madam, and this is the only hospital, big hospital in that area, madam. That Eratupeta municipality, madam, this is the only big hospital, madam. What happened, madam? They have, madam, already, madam, third time before this honorable court, madam. Already, madam, if your lordship sees page 19 para R, they have already, madam, brought this issue to this honorable court, madam, in SLP number 12357 of 2022, madam. This court, madam, rejected their appeal, madam. They are the bona fide litigant, madam, where, madam, they will not, they have, madam, one side, madam, they
what by learned friend?
Your lease in favor of the corporate
Yes,
debtor.
but Lord, it has to be separately, Lord, sold under the SARFAESI proceedings.
Also, madam, one more thing is that, madam,
can you see
They gave up their first charge so that this could be entirety could
sold
be
as a going concern to maximize the value.
maximize the value.
But still,
And also, your lordship, what my learned friend was strengthening liquidator.
Not a case.
This is the
the bank has taken,
the
madam.
third round of litigation, Supreme Court, your lordship.
Also, my bank has utilized the section 13 subsection 11 of SARFACI. They have assigned the land into the liquidation estate. Your Lordship knows very well that section 13 subsection 11 of SARFACI, the bank can assign or transfer or sell the property which was mortgaged to them. Here, they have given a property to the mortgage of 19 years to the corporate debtor. Other side, they have given the corporate guarantee, and they have given the deposited the title deed with the bank. The bank, because the land and building cannot be separated, has decided to relinquish the property into the liquidation estate using the section 13 subsection 11. They have assigned it to the liquidation estate. Then the liquidator sold the land for 36 crores, and one more land and building is there, which we will realize 10 crores rupees. Here, the promoter is before this honorable court without having any locus.
Both are relinquished to that.
Today,
There are two
against an order where the NCLAT hasn't considered any of this.
No, but
The
what's the
only
case?
reasoning.
There's nothing on merits.
And they are third time.
The only reasoning of the adjudicating authority.
Ultimately, this was a lease of 99 years.
Yes.
So, Union Bank of India was entitled to relinquish its security under 3611.
No, that's not the reasoning of the adjudicating authority, with respect.
Look at it from this point of view. The purpose of doing this was to ensure that the entirety is sold as one going concern.
Today,
otherwise they would be selling off the hospital superstructure and the land separately.
Today, your lordship will see what's happened, my lord. Under the liquidation sale, out of 36 crores, 6 crores are attributed as a liquidator cost. If, my lord, there is a SARFACI proceeding, there will be entirely independent rights of the promoter. And
That is the case. Let them deposit 50 crores. Let them.
The NCLAT has not even addressed these facts. The NCLAT has only ousted.
But ultimately, this is the end of justice line.
My lord, here we're losing all, my lord, shape of the corporate identity, my lord. It's not the corporate.
I think we leave it.
Very well.
Thank you.
I'm obliged.
The Lordship was seeing two documents. The Lordship rose last time. The Lordship was seeing two documents when the Lordship rose last time.
Plain say.
Test to me.
Translated plain last time we gave.
What, Paulus?
The translated plain.
Yes, we have.
Was this in respect of land used for trade and commerce, or was it really basically?
Well, as the whole thing was converted, intended for that. Let me show the document. He has a copy of that. We can hand over the.
Intended to be used. Their order 711, they admit that it was intended to be used.
So it was not actually in use.
Lordship, the translated prayer, your lordship has.
Kindly,
the translated prayer, which your lordship.
It's for the benefit of my lord, the Chief Justice.
I want to show Mullis 3 parts of the plaint and 3 parts of the agreement. That's it. So just let me show the plaint first, Mullis. May I?
Yes.
Last time I gave you the copy. Huh?
Yes, my lords, give it. Why didn't you bring copy also? In such a other the matter is going on. Arguing will do this.
Sued for a declaration.
I'm so sorry.
And then for an injunction.
Lordship.
Actually, mandatory injunction.
Can I show three parts of the plaint, Wallace, very quickly, 3 parts.
Yes.
Straight away. Now, let us kindly come to 122. 119 it starts. What is there is there, nothing else can be added. This is the entirety and then the agreement. 119 it starts, come to 122. A piece of uncultivated land known as Tulsi Industrial Stage in an area including the development thereof, the charter which is follows at 122 Mullis. Now come to 123. My lord has got 122? Yes, 123 Mullis. Entitled Agreement for Development of Land on the top of 123. Then your lordship will come to 124. January 22 to 22 from the plaintiffs to the defendants and the development works etc. also shown on the spot. All the details are requested by him and all the documents made available. Now come to Mullis 127. The purpose of the enterprise as well as development, and the cost is given at 127. Now 129 is most important. The cost is at 127, 129 para 4. The party of the first part and the party of the second part have handed over a vacant peaceful possession. It is for the party of the third part on execution of agreement to sell. Hence, this agreement for sale is with possession, and the party of the third part is entitled to occupy and possess the above property for their bona fide industrial purposes.
This land was not today used, on that date used for the.
Yes, it was not on that date used, but the whole purpose of the enterprise is commercial. Now come to 131.
It's a simplicity agreement for land. It's
Now
not really a
kindly see
commercial agreement in that sense.
Kindly see 130.
Not an industry. It was not a land for industrial use which was being transferred for industrial.
It doesn't have to be. The purpose of the enterprise for which I entered into the contract was to develop for industrial purposes. The master plan was changed. Master plan was changed already. Just see page. Let me just finish 131. Then I want to show page 52. Just come to 131 first. Then I want to show page 52 is very, very important. Of the agreement.
What is the relevant part of the Commercial Courts Act? What does it say? What is the terminology?
Yes, Malas. May I just show the agreement after one page, Malas? 131. I want to show, Malas, the agreement after 131, Malas. Since the Lordship is on it. Please turn to 131. In the middle is, Malas, the same enterprise of Tulsi Industrial Estate. In the middle, para 11. Now come to, Malas, the agreement inter alia at page 52. We have applied for town planning permission. And Malas, they have applied for town planning. Just come to Malas page.
1C is agreements relating to immovable property used exclusively in trade or commerce.
Lordship, please.
Yeah.
And your
Now
lordship
just tell to
used means
you were going to the intended use was for industrial purposes.
Now come to 52, Malas. Just 52. Just come to 52. They had applied. They have obtained also subsequently. Whereas the party of the first part, this is very important, 52 Malas, have applied.
There was nothing in the agreement or even in the plan to indicate that this was land which was immovable property used exclusively in trade or commerce.
Just see exclusivity, page 52. Answer to my Lord the Chief Justice's query. 52. 52, if my Lord will see, last part. Whereas the party of the first part have applied to Town Planning Authority for necessary approval of construction plan, and the said application is granted by the authority on 2020. Whereas the idea and the object is only one enterprise. What else?
It was not immovable property in use for commercial end.
Let me put it like this. It does not have to be a full-fledged bustling.
Is exactly to that effect.
But it doesn't have to be a prior existing bustling commercial complex. It can be the object of the agreement is what are your Lordship dealing with? Your Lordship is sending me or not sending me to commercial court on the basis of the enterprise. The enterprise is commercial. It is to convert. Now, it may not be that time. It takes time.
The agreement between the parties. The simplicity and agreement.
May I say one more thing? May I say one more thing? This is a project of national importance for which I got this. He's not consequential. This is important for Lordships. Page 40 tells you that this is part of the Mumbai-Baroda Expressway. And this is vital for that. The contract was for 11 crores, 13 crores. 14 crores. I've paid him 3.5. I'll pay him the balance. If you want some interest for this project, just see page 40. You are actually affecting.
7-11, my lords. That is something.
Sit down and settle it outside.
That, of course, that's independent. This is 7-11, my lords.
In a mediation,
7-11, there is no
right, but in a mediation, if it goes, this project will be a small patch.
Negotiate with him. He will ask for his price. That's all. Thank you, Dr. Singh.
Grateful.
Add one sentence that liberty to mediate if possible, if we agree.
That's independent.
27.
Grateful, man.
Obliged.
Hello, this is an arbitration petition.
How much is the claim?
$54,000.
Euros. That will work out to approximately
41 lakhs, around 41 lakhs, my lord.
That's all.
My lord, I have a suggestion, my lord. Maybe actually mediated, I think an attempt could be made at mediation under the Supreme Court Mediation Center. Subject, of course.
Are they appearing?
Service is complete, my lord.
On the Sai Entertainment?
Yes.
We can say mediation, and then if that doesn't succeed, in arbitration.
Yes.
Whom should we appoint? Such a small claim. Appointment. How much is the claim?
41 lakhs, Your Lordship.
41 lakhs.
Yeah.
We'll refer it to the Delhi International Arbitration Center.
Okay.
Arbitration and the auspices of the Delhi Arbitration, International Arbitration.
Or any lawyer, Your Lordship, if you'd like.